And hello, everyone, and welcome to Uncivil Law, where, as always, we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today will be the day I earn that subscription. For today's story, we're dealing with one of the most consequential cases of this term, the case dealing with freedom of speech as it relates to a person who designs websites. This is the case of 303 Creative versus Elenis. The case is fairly simple. This is Masterpiece Cake Shop, but in a slightly new context, right? So you'll remember a couple years ago, there was a guy who makes cakes. Someone wanted him to make a gay cake for a gay wedding. And he's like, no, I'm not about that because I don't believe in it. I don't believe in it. And they say, well, you're discriminating against us. You can't discriminate on the basis of sexual orientation. You know, you'd serve straight customers and cis customers, but you won't serve us. And so that case went to the US Supreme Court, and they punted it based on some issues that happened in the case that made the issue a little bit tenuous. Also, the case is a little bit more removed from a pure speech context, right? So obviously a wedding cake can include writing, and it can include themes and symbolic speech and stuff like that. But, you know, it's not as pure speech as, for example, a website. So when we get into questions about what is speech and what is not speech, right? A website is much more in the speech territory. So this case is a better vehicle, is the term we use in law. It's a better vehicle to decide the issue because it raises a pure issue and it's uncomplicated. It's also an uncomplicated case because the entire case is based on stipulated facts. Okay. 303 Creative does not make websites for weddings at all. They want to. They're a graphics designer. They make other things, but they don't make websites for weddings. But they'd like to only make it for heterosexual weddings. They'd like to not make it for gay weddings. And so they're suing this on basically, it's like, well, this is a chilling effect on my speech because this regulation is in place. So this case is also a good vehicle in that sense because there is no complications to this case, right? We don't have the same complication we had in Masterpiece Cake Shop, where there was the problem with the pre-enforcement board and how they were reviewing the case and stuff, because none of that happened, right? This is all based on what would occur. It's like, I want to do this, and you are preventing me from doing this. And so she's bringing a pre-enforcement challenge, which you can do under some circumstances. And it seems like she has all the T's crossed, right? She has a pre-enforcement challenge. It's like, I'm in the business of graphic design. I make other things. I'd like to make websites for weddings, but I'd like to not offer them for gay weddings, only for straight weddings. And the Colorado says, okay, well, we're going to make you. She'd also like to, on her website, say, I don't support gay weddings. She's like, you can't do that. The Colorado says two things. You can't advertise that you will discriminate, and you can't discriminate. So you can't put on your website, I don't like gay weddings. And you can't also refuse to provide websites for gay weddings. Right. Okay. So we're on a stipulated fact pattern. It's 10 pages worth of stipulated facts. So it's a fairly detailed stipulated fact pattern. We got a woman here who wants to create websites for straight weddings. She'd like to say that she does not support gay marriage, and she'd like to not provide the websites for the gay weddings. Colorado says you're a place of public accommodation. You're a business. You know, you're a business providing a service, and you have to provide a service equally to all your customers. And she's like, yeah, though, but my business and my service is speech. So First Amendment problems. Yeah, so that's the case in point. I'm going to read this a little bit more now that I've described it a little bit. So the case involves Lori Smith. Lori Smith is the owner and founder of the graphics design firm 303 Creative. She wants to expand her business to include wedding websites. She does not make any wedding websites now. She'd like to, though. However, she opposes same-sex marriage on religious grounds, so she does not want to design websites for same-sex weddings. She also wants to post a message on her own website explaining her objection. So she'd like to say, I don't do the gay marriages, and also not do the gay marriages. She wants to say it and also not do it. Colorado Anti-Discrimination Act, which is the same act that was in play in Masterpiece Cake, prohibits businesses that are open to the public. She makes her services generally available. So, and they have stipulated that she is a place of public accommodation in the facts. So that's a stipulated fact. So she is a business open to the public. and it prevents them from discriminating on the basis of numerous characteristics, including, for example, sexual orientation. The law defines discrimination not only as refusing to provide the good or service, but also publishing any communication that says or imply patronage is unwelcome because of the protected characteristic. So you can't put up a sign on your business, as it were, says, we don't serve gay people. You also can't not serve the gay people. That's what they're saying. Even before the state sought to enforce, this is a pre-enforcement challenge. Smith and her company challenged the law, saying on a pre-enforcement challenge, I want to sue before I even do anything, which you sometimes can do. It seems like she's checked all her T's on that box. The district court granted judgment for the state. So the district court said, state, you're right. Court of Appeals said, state, you're right. She has to provide the gay websites. Thus the question, does the application of Colorado's Anti-Discrimination Act compel an artist to speak or stay silent, violate the free speech clause? Okay, so this should get real spicy. Let's go ahead and do all those things. I'm excited. I know you're excited. This is a very interesting case, so let's go ahead and listen to this. Let's get started with this. Oh yeah, I had this problem the other day with the browser not loading properly. No problem. I know how to fix this. Oh no, there it goes. Is it going to load for me? It's being very slow. I have another way to solve this problem. I think. We will return shortly. You have a right to refuse service? Generally speaking, you do, but not for protected reasons. That's the wrinkle, right? Okay, no problem. All right, great.
Argument first this morning in case 21-476-303 Creative, LLC versus Elenis. Ms. Wagoner?
Mr. Chief Justice, and may it please the...
And Cosmic Slice asks, could the also refuse to make them based on race and religion too? Presumably, yes. Presumably, yes, because the First Amendment trumps. Like, you cannot force a person to speak. So I don't know whether or not that will be their answer, but that's presumably the correct answer legally. The First Amendment trumps. The statutes that exist for anti-discrimination statutes necessarily must fall to the Constitution. The Constitution must win. So it must be true, like logically, that yes, the business would have a First Amendment, would have a right to refuse to provide its business to anyone for any reason. And the state could not make protected reasons because the First Amendment must trump. So that's, we'll see if that's their argument or not, but that would be the logical thing.
The court. Lori Smith blends art with technology to create custom messages using words and graphics. She serves all people, deciding what to create based on the message, not who requests it. But Colorado declares her speech a public accommodation and insists that she create and speak messages that violate her conscience. This court rejects such government-compelled speech. In Hurley, the court considered a very similar issue, asking two questions. Is there speech, and is the message affected? That test is easily met here. Colorado agrees Ms. Smith creates speech, and the law undeniably affects her message. She's not asking this court to create new law, but to apply its precedent. Colorado first says this case is about a sale. It's not just about a sale. The state forces Ms. Smith to create speech, not simply sell it. Next, Colorado says it can compel speech on the same topic. But Ms. Smith believes opposite-sex marriage honors Scripture and same-sex marriage contradicts it. If the government can label this speech equivalent, it can do so for any speech, whether religious or political. Under Colorado's theory, jurisdictions could force a Democrat publicist to write a Republican's press release. Colorado's last resort is to argue that it can at least compel the same expression. But even the same expression can mean different things, like a black sculptor who carves a custom cross to celebrate a Catholic baptism, but not an Aryan church rally. If the government may not force motorists to display a motto, school children to say a pledge, or parades to include banners, Colorado may not force Ms. Smith to create and speak messages on pain of investigation, fine, and re-education. I welcome this court's questions.
I like it. I like it. Yeah, this is right. It's like, yeah, you can't force them to create the message, and even literally the same message might mean different things. I like her example. It's like you can't force a carver to create a cross for everyone because the message might not be the same in all contexts. I like it. It adheres to First Amendment principles. Let's go. Let's listen.
Counsel, would you spend just a few minutes on whether or not this your case is ripe?
And for people asking, like Joanne's asking, so if my artistic expressions through cooking. See, this is one of the reasons this case is a better vehicle than Masterpiece Cake. Because this case is much more purely about speech, right? She's creating a website. The website is speech. Like, is creating cooking expressive? Yes, perhaps. But is it speech, or where is it in the speech menu, right? So the reason that this case is a good case to hear is because it eliminates that complication that was present in Masterpiece, right? So whatever we might say about a cook or a tailor or whatever, right? Whatever, this is the outer edge. This is the outer edge, presumably. Like, if the First Amendment doesn't provide protection here, it doesn't provide it anywhere. So does it extend further down the line? Does it extend further down the line to a cooker? Does it extend further down the line to a tailor or something like that? Does it extend further removed? I don't know. But if not here, then nowhere. So your question is interesting, but a little bit inopposite, because we're trying to decide, well, this is pure speech. And so, well, is there a conflict here? And then presumably, if the answer is yeah, no, then the answer is no everywhere. If the answer is no, the answer is no everywhere. If the answer is yes, then it doesn't necessarily flow that the answer is yes everywhere. We'd have to get into issues dealing with whether the speech is incidental to the conduct, or there's other tests to deal with it. But that's one of the reasons this is a good vehicle to decide it, because we're trying to deal with a pure issue. Kiwi New York Upstate says, it sounds like a person can be forced to do work for anyone. If they can't decline, it sounds like slavery just because they have a business. That's not quite right. No, but thank you for your super chat.
Sure. This court has considered pre-enforcement challenges before, and in those contexts, it has looked at the facts. This is one of the strongest pre-enforcement cases I think that this court has considered, in that the parties have stipulated every message that Ms. Smith would create has a unique, customized message, and that it celebrates a wedding and celebrates a marriage. It's also difficult to imagine a scenario where there isn't a more aggressive enforcement history by Colorado. Ms. Smith's speech has been chilled for 6 years. She has been unable to speak in the marketplace. She's ready to do so today, and she's ready to post her website statement today, which makes this case ripe.
Ms. Wagner, unless you're not through with that, sorry.
I'm through.
Okay.
Thank you.
Can I give you a hypothetical? It's not really a hypothetical, because I happen to have 2 clerks in my chambers this year who are engaged. So in looking at this case and preparing this case, I looked at their websites. And so the hypothetical is about, like, I'm going to call it the standard website. They both have their names on it, the date of the wedding, a picture of the couple. Then there are a bunch of places that you can click to. And one is the schedule of events, and the other is travel and hotel arrangements, and another is favorite things to do in town while you're here, and another is registry. So that's what most websites look like, yeah? And they're not particularly ideological, and they're not particularly religious, they're not particularly anything, all right? And then there's a tagline, just like the tagline in this case, about sort of who created the website, or whose graphics and design and typefaces and so forth were used in the website. And so one of them says, I'm going to substitute a woman's name just to not advertise, but one of them says, made with love by Amber, right? Mm-hmm. It's actually bigger than the 303 tagline. So I guess what I want to know is, suppose Amber wakes up tomorrow morning and says, you know what, I don't want to do those websites anymore for same-sex couples. Could she do that?
In terms of creating new websites?
No, you know, like she's providing these templates and she has all these designs and typefaces and that's what people use when they create their own website, because they give her the date and they give her the list of hotels and so forth. So can Amber wake up and just say, no more gay couples?
She can't say no more gay couples, but a speaker does have the ability to decide not to speak under the law. But I think the hypothetical that you're mentioning is assuming that it's a plug-and-play website, essentially, that the website is already made and that the speech creator isn't making any additions to it.
No. I mean, just like, I have to think that your client does something similar. You have lots of graphics, you have, typefaces, and, maybe, some are a little bit more you talk to the client and some are a little bit less you talk to the client. But basically, clients are coming in and they're saying, we just want a standard website, that tells people where to stay and how to travel there and what our favorite things to do are. And the question is, can a website designer say, sorry, that's not my kind of marriage?
The website designer...
There's no scripture, there's no ideology, there's no nothing.
There is ideology, and this court has already recognized that there is ideology and different views on marriage.
Good pushback. Good pushback. Nice. Kagan says there's no ideology. She says there is ideology. Good pushback. And right. That's Obergefell. Right. She's correct. She's good response.
The court's promise in Obergefell is to protect those who would believe marriage is between a man and a woman from having to express a view that violates their conscience. But
Okay, so I think that if I understand you, you're saying, yes, she can refuse because there's ideology just in the fact that it's Mike and Harry and there's a picture of these two guys together.
That is speech. You are announcing a wedding, and if you believe the wedding to be false, then the government would be compelling you to say something that you otherwise wouldn't say, which makes it content-based.
So it's really nothing about the content of this speech. I mean, it could be Mike and Pat, and you don't...
It is about the content of the speech. She doesn't want to say that content. And the king is like, it's nothing about the content. It is about the content. She doesn't want to say that content. She doesn't want to say that message.
Actually even know whether Pat is a woman or a man. There's really nothing about the content of this speech. Am I right? In your case, you have like scripture examples, and so that might, be different, maybe. But you're being forthright and saying it's really not about that. It's nothing about the content of the speech. It's just that the content is being whatever the graphics and typefaces and which hotels are have been reserved for the wedding, it's being used in a same-sex marriage.
No, it's not about the use. It's about when a person is creating speech, it is what is the message that they are expressing. The Hurley framework asked this court to first look at, is there speech? And there clearly is. Words, graphics, text, videos, pictures. That's speech, and it's generally protected. The second is to ask, is the speaker's message affected? And when you're requiring a speaker to create a message to celebrate something that they believe to be false, you're compelling their speech, and it's affecting their message.
So their message is not actually the content of the website. I mean, this is Justice Kagan's point. We could have a situation in which the identical website is being offered, one to Harry and Anne and one to Harry and Steve. But everything on the website is exactly the same. I think I hear you saying that the message that the designer would be sending when she offered the website to Harry and Steve would be different and contrary to her beliefs, and that so it's the implicit message that she's endorsing that wedding that's the problem.
No, she's not. It's not about whether she's endorsing it. She's not speaking through anything but creating the speech. And when you switch out those names, you're switching out the concept and the message that is actually in the website. Think of an example of God bless this marriage.
Suppose that
Well, that's a particular message. But I looked and to your proposed website, and I turned to page 51. It says, save the date, Lily and Luke, November 17, 2017. So what's the message if it says save the date, Lily and Lillian, or Lily and Marion? What's the message there?
That's an invitation to celebrate a marriage.
But why is it your invitation? I go to a wedding website. It's something that I send, meaning you, your clients. I send it to my family and friends, or Lily and Luke send it to their family and friends. You don't send it. They go to this website. You're not inviting them to the wedding. Lily and Mary are. So how has it become your message?
In the same way that it is the message of a ghostwriter who writes an anonymous press release or a book, it is still that writer's speech. The whole point of the compelled speech doctrine is to ensure that
what's the limiting line of yours? Justice Kagan asked you about.
Personally, I'm not sure there is a limiting line because the First Amendment trumps. So I'm not sure there is a limiting line. They can just refuse to curate the speech because it's speech. The First Amendment trumps. But we'll see if that's their answer.
Another website designer. But how about people who don't believe in interracial marriage? Or about people who don't believe that disabled people should get married? Where's the line? I choose to serve whom I want if I disagree with their personal characteristics like race or disability. I can choose not to sell to those people? This website? Because it's my speech?
Not at all, Your Honor. The Hurley framework provides that in a public accommodation context, the first thing the court looks at is the speech creator otherwise serving those in the protected class and expressing other messages? In the context of race, it's highly unlikely that anyone would be serving black Americans in other capacities, but only refusing to do so in an interracial marriage context.
Suppose we agreed that the website designer could not refuse to provide that service to a same-sex couple if the website is of the kind that Justice Kagan described. What does that say about the particular case that is before us on stipulated facts?
Well, it would say that the court isn't considering those facts because that's not this case that's presented to them. But at the same time, even that website...
Well, so what are the differences what differences do you see between her hypothetical and the actual case that is before us?
She provided a number of hypotheticals. So in terms of assuming
Just one, Ms. Wagner.
The hypothetical
website
where there is a website and basically all the website operator does is to put in the names of the two people who are getting married.
That's not a service that, or speech creation that Ms. Smith provides. But if she did provide that, if it's a plug-and-play website where the couple, for example, is putting in their names and using their website, then you don't have compelled speech because you don't have a speech creator. But even in the context of putting in names...
I'm sorry. Show me on your website. Show me on the pages of your petition for a writ of certiorari. Show me a page on that website that is an endorsement of a marriage as opposed to the story of a couple.
Well, either one violates the compelled speech doctrine.
No. Please show me a page on your website. It's attached to your petition. I'll start you on page 51.
Pages 53, 52, 54, 55, and 56 all represent an invitation and a celebration.
53 says our photo gallery. 54 says funny dating story. How is that your story, your photo gallery? It's the couple's photo gallery. Page 54 is funny dating story. It's their story, not your story. I'm looking at every page, and basically it's the story of the couple. It's a date on page 51. 52 is our special day. 53 is RSVP, our photo gallery. 54 is a funny dating story. I keep looking at all of the mock-ups, and all of them relate to what Lily and Luke are saying or doing, who they are, who are their grooms, who aren't who's their bridesmaids. I don't understand. How is this your story? It's their story.
If you're asking whether, first of all, book authors, newspaper editors, those who write all kinds of publications may be writing about someone else's story, but it's still their speech, and it's
they're
still
not
Preach.
public accommodations in the same way.
Ms. Wagner, can I ask you a question about a heterosexual couple? So, in response to Justice Sotomayor's questions, I took it that your website, where you say, why a wedding website, you go through, and it seems like Ms. Smith was careful to say things like, I fully customize the look, feel, theme, message, color palettes, etc. And then there's the engagement story page, a page inspired by you and written by Lori that captures and conveys the cherished storybook of your love. So I want to ask you a hypothetical about a heterosexual couple that comes to your client. And their wedding story, that they want to write under the engagement story page goes like this. We are both cisgender and heterosexual, but that is irrelevant to our relationship, which transcends such categories. We knew we were soulmates from the moment that we met, and on and on. Would your client publish that site?
Yes, she would publish the site, because her objection, assuming that the marriage is between a man and a woman, she would publish it, and that there's no message.
Even though that narrative, I assume, is inconsistent with her biblical views about marriage. Or I'll give you another related one. A heterosexual couple comes to her, and in the engagement story part, writes a story that goes like this. We met at work. We were both married to other people. But what began as late nights at the office quickly turned into love. After 6 months, we realized we could be happy only with each other. So we decided to begin our story today, got divorced, and are marrying each other. Does she publish it?
I don't believe that she would. I also don't believe that she would embrace or express a message that would essentially say it doesn't matter whether there is a marriage between a man and a woman. She wouldn't create that speech
So
either.
It's about the message and not about the sexuality of the couple that asked her to express it that matters.
Yes, which is exactly how the court decided the case in Hurley, but it's also in other cases as well. The Pacific Gas and Miami Herald cases. This court has routinely looked at compelled speech cases to determine if the message...
And Ms. Wagner, can I just ask you to clarify before we move on? When I first asked you the question about the cisgender heterosexual couple, you said you thought she would publish it, but then it seemed like you wavered and said something different.
If I could just clarify the hypothetical, the second part of the statement was that it didn't matter. Is that
concepts of gender or, sexual orientation were irrelevant to their relationship because they believe that those categories don't matter. What matters is their union of souls.
No, she would not create a website that would say that, because that would violate her beliefs about what Scripture holds on marriage. In the same way, though, this law and the compelled speech doctrine protects the LGBT website designer, who won't be forced to have to create a website essentially advocating for a view of marriage that they don't hold.
Can I ask? No, go ahead.
No, please.
No.
Justice Gorsuch.
I'm sorry.
No.
One can view these websites, or last time around we had cakes, as either expressing the maker's point of view or the couple's point of view. And that's really at the heart of a lot of this. And I guess I'm a little confused, because sometimes, as I understand it, you're saying inherently here, it is my client's point of view and not just the couple's point of view. I'm being compelled to speak. I get it. And sometimes Colorado agrees with you. For example, when it comes to the example you just gave, which is why I popped up. I believe it was William Jack in the Masterpiece Cake example, where Colorado said, he didn't have to create cakes that spoke against same-sex marriage, that would be his compelled speech, not just the couple's speech. So what do we do about this level of generality problem, if you will, where people slide back and forth based upon their priors? How do we avoid that as a court? What rule would you have us draw?
The court should follow a rule that says if the speech is being created and there's an objection and that objection is contained in the message, it is protected speech. And the government can't slide up and down.
Tell me why it's not protected speech. The identical message that Justice Barrett put forth, but by a disabled couple. And you say, I don't want disabled people to get married. I think propagating a disability is against my personal belief. It doesn't have to be religious because we're not dealing with the religious part of this. I don't want to speak that message. I, too, believe that two disabled people getting married and telling their story of how they got in love, I'm not going to serve those people because I don't believe they should be married. What's the difference between that and I don't believe black people and white people should get married?
What matters is what the objection is that the speaker is being asked to create and whether the objection
is... But if I just, that's my objection. I don't believe they should be telling their story.
If you don't believe they should be telling their story and what they're asking you to do is tell their story, then you don't have to do that.
So it doesn't really, there is no line on race, there is no line on disability, ethnicity, none of the protected categories in a public accommodation law.
There is a line. There's a very clear line, and it's worked very well.
But tell me what the clear line is. You're saying it's compelled speech, correct? Not compelled service.
I'm saying that in the public accommodation cases, this court has routinely looked at whether there's speech and whether the message is affected and whether the objection lines up with the final speech.
But the one line that you're missing is Justice Gorsuch's line. Whose speech is the person viewing it going to think is talking?
The Pulitzer Prize doesn't go to the customer or to the subject. It goes to the photographer. And there's a reason for that. That reason is because you are requiring that artist to speak a message. It is their work. It might also be the customer's, and the customer can use that. But the First Amendment is broad enough to cover the lesbian website designer and the Catholic calligrapher. The line is that no one on any side of any debate has to be compelled to express a message that violates their core convictions because, as this court found, it's demeaning to them.
So
I'm sorry.
Can I ask you a hypothetical that just sort of helps me to flesh that out? Because I also heard you suggest earlier that there's something different about race. Maybe the person wouldn't sell to someone of a different race. So suppose you say that photography is expressive. Can you give me your thoughts on a photography business in a shopping mall during this holiday season that offers a product called Scenes with Santa? And this business wants to express its own view of nostalgia about Christmases past by reproducing classic 1940s and 1950s Santa scenes. They do it in sepia tone, and they are customizing each one. This is not off a rack. They're really bringing the people in and having them interact with Santa, children, because they're trying to capture the feelings of a certain era. But precisely because they're trying to capture the feelings of a certain era, their policy is that only white children can be photographed with Santa in this way, because that's how they view the scenes with Santa that they're trying to depict. Now, the business will gladly refer families of color to the Santa at the other end of the mall who'll take anybody, and they will photograph families of color in other scenes. So they're not discriminating against the families. What they're saying is Scenes with Santa is preserved for white families, and they want to have a sign next to the Santa that says only white children. Why isn't your argument that they should be able to do that? And maybe it is.
I think they should be able to do that because the creation of the photograph is the creation of speech, and they don't want to create that photograph. They don't want to create that speech. the copyright belongs to the photographer, right? So the creative aspect is the photographer's. That's the nature of why the copyright belongs to them. It's like, I don't want to create that speech. So it's like, yeah, I mean, okay, that's, I think, the right answer under the First Amendment. It doesn't mean that they're good. It doesn't mean that they're nice people. One would imagine that word will get out about them and they won't get hired and, they'll be outcompeted and the rest of it, but okay.
Because in the photograph itself, the objection is not contained in that photograph. But in addition, I think it's important to remind the court that
No, don't leave. Sorry. What do you mean? I mean, the objection, just like your client's objection, is to expressions that violate their own views of what is being depicted. And so their view of what is being depicted is that a scene with Santa and a child on the lap and all of that in sepia tone, trying to harken back to the good old days, should only have white children in it. That's their firm belief. They are not willing to take photographs of Black, Hispanic, Asian children on Santa's lap. Why is that any different than a situation like this?
Because the specific objection that you're including is not necessarily in that photograph, but even if it were, this court has protected vile, awful, reprehensible, violent speech in the past, and it...
Damn straight. Damn straight. That's the right answer. That's the right answer. This court has protected vile, awful, reprehensive, violent speech. Correct. Correct. So first of all, I don't agree with your hypothetical. If I did, they should be allowed to deny it because it's speech and they're allowed to make speech. They're allowed to, that's the nature of the First Amendment. That is the right answer.
Is never compelled.
No, I'm just asking you, why is the objection of the web designer, as Justice both Kagan and Sotomayor has pointed out, when we look at your examples, they just say things like, please come to the wedding on this day.
Precisely. It's an invitation to a wedding.
Okay, so if my hypothetical is an invitation to join me in the 1950s, through looking at this photo, you say one is different?
I say that same clarity of the message isn't in that photo, but there are difficult lines to draw, and that may be an edge case, but this is not. We have a creator of speech and a very clear message.
It may be an edge case, meaning it could fall on either side. You're not sure?
I am sure, and that the message isn't in the product. It's not in the photograph. But even if this court were to find that it was, the court would still have to protect the speech. And the court could draw a line in a different place, as it has juxtaposed Loving and Obergefell in terms of the beliefs between same-sex marriage.
So just,
In Obergefell, did the court say that religious objections to same-sex marriage are the same thing as religious or other objections to people of color?
No. In fact, it said that decent and honorable people hold beliefs about marriage, believing that there's a gender-differentiated marriage and that that's based on reasonable religious and philosophical premises. When we review Loving, there's a very different...
Tell me how to write this decision for you that draws the line just on gay marriage, because that's what you seem to be saying right now, but draws a line that doesn't affect my example of a disabled person or an interracial
I'm not sure it's
couple.
possible or desirable to
You're
draw that line.
saying it's just because it's compelled speech.
I'm saying that the interracial couple, the disabled person, the lesbian graphic designer, the Democrat, the Republican, no one should be compelled to speak a message. And this court has never found a compelling interest that is narrowly tailored.
You're saying a print shop, a web designer, a cake maker, a photographer, a jewelry maker, they can refuse to serve anyone they want to refuse because they have a deeply felt belief that taking pictures of black couples, black and white couples, taking pictures of disabled people are going to believe that they're speaking that message.
I'm not saying that at all. What I'm saying is that in every free speech case, the court looks first, is there speech? In many of the situations you raised, there would not be speech.
But why not? I'm saying your identical website, and I don't see a page in here where it says, I am speaking 303. That's on your personal website. It's not on the wedding website. I've asked you to show me where, in which pages, it's your message as opposed to the couple's message.
Every page is my client's message.
But
just as in a newspaper that hosts an op-ed written by someone
so why
else.
Does it,
or Hurley, the parade.
But then why does an off-the-shelf website, the creator of an off-the-shelf website, is then speaking? That's what you're saying.
No, because the compelled speech doctrine doesn't apply once you've entered that speech into the stream of commerce. When the speech is completed, the compelled speech doctrine no longer applies. But in addition, there are 20 states that have filed an amicus brief in this case and said they are right now using their public accommodation laws to allow message-based protections as Hurley would require, and they're not experiencing these issues.
But you're not asking for that. You're saying, I don't want to serve a particular person, a disabled person, a black and white couple, a disabled couple, a gay couple. You're basing it not on the nature of the message, you're basing it on who you're serving.
I don't think that's a fair characterization. The stipulated facts in this case are that Ms. Smith has LGBT clients. She serves them regularly. She has all kinds of clients.
Tell me how that's different, by the way. What you're basically saying is in our Oleg barbecue case, the company there said, I'll serve blacks, but only on a takeout window, not inside my restaurant, because that sends a message that I endorse integration.
Ms. Smith isn't looking to send a message through her conduct.
What you're saying is, I want to give gay couples a limited menu, not a full menu. Just the way that luncheonette said.
No, just as this court found in Hurley, she's being asked to shape her speech.
No, anytime you want to stop, like, so what you're saying is, Justice Kagan, would be fine. So what you're saying is, no. So what you're saying is, no. Okay.
By a third party. And it's about what messages she is creating. In Ollie's barbecue, they weren't engaging.
When I sit down to eat a meal by a full chef who creates this beautiful picture on a plate, why can't he say, I make specialized meals for my clients. I will not serve a black person. I won't serve a disabled person because they can't appreciate fully what I'm creating. That's basically what you're saying.
No, I don't think it is what I'm saying. We're conflating service and speech in that instance. A chef
isn't. But why is yours not a service?
May I answer the question?
Yes.
Because it is creating speech. And the public accommodation law is broad enough to ensure that we're not crushing consciences not just of Ms. Smith, but of her LGBT friends.
Thank you, counsel. If your client's website not so fast.
New way of doing it.
if your client's website was the same as it is, but the only indication of any limitation was a tagline at the end saying these services are for heterosexual couples only, could that constitutionally be applied under the Colorado statute?
The speech could be compelled if you're suggesting that she essentially has a no customers only sign, and that's exactly.
As in your case, no websites. No websites are available except for heterosexual couples.
For marriage?
Yeah, same thing.
Generally speaking, no. In Ms. Smith's particular case, all of her websites are created, they're original, customized to the story. And so in that instance, she believes same-sex marriage to be false and couldn't create the speech.
Okay, what if it said, I won't provide websites for anything other than heterosexual marriages because of religious reasons? Could that be covered? Or is it simply the invocation of religious basis for the objection that protects it from coverage under the statute?
The religious basis is not determinative here. This Court has provided broad protection for religious speech, but it wouldn't matter. This compelled speech doctrine applies in a host of situations and cases that are not religious.
I guess I don't understand that answer. In other words, is it simply adding for religious reasons to the label that would change whether it can be regulated or not?
I think what's important is that the objection is to the message she's being asked to create. And so if she believes she's being asked to create a message that violates her convictions, whether those convictions are based on a moral reason or a religious reason, it would be protected.
Okay, thank you. Justice Thomas? Justice Alito? Justice Sotomayor? Justice Kagan?
Yeah, I wanted to take you back to my opening questions and then Justice Alito's question about how your case is different from my hypothetical. And maybe the way to sort of cut through some of this is to not make it a hypothetical and just ask about your client. So Mike and Mary go into your client. We love your graphics. We saw them someplace else. We love how this looks. Here's what we want. We want a standard site, our names, the picture, the hotels, the registry, just that. And you say okay, don't you?
Yes, assuming all the details line up with the message that she's willing to create.
Yeah, I mean, then they say, we don't want your scripture. But that's all right with you. They don't have to have scripture.
No, they don't have to.
Yeah, they can just have a standard site, right? Okay. So now it's not Mike and Mary. Now it's Mike and Mark, and they want the identical site. We saw Mike and Mary's site. We loved it. We're getting married, all they want to change is the date maybe, or, their names, whatever. We loved it. And they don't get it. And the question, and you say no, right? You wouldn't be up there if you weren't going to say no, right? They can't get that site.
Yes, because the same words can even convey different meanings.
Yeah. So then, the difference is one couple is opposite sex, one couple is same sex. How is this, what are the different meanings? What is the speech?
Really? Seriously? What are the different meanings? Okay.
That your client is expected, is required to provide in the way I expressed it to you.
The purpose of the websites is to celebrate an upcoming wedding. It's to announce a wedding. And
it is to announce a wedding. This is a standard site, there's not a whole lot of, gosh, isn't this great? It's just like, here's the registry, It's announcing the wedding. It's announcing where to get the hotel reservations and so forth.
I'm going to start a business at this point just opposing weddings. That's going to be my graphics design service. That's all I do. Is I create websites that oppose weddings. This wedding sucks. You should not support this wedding. See who I can get to support to. See if I can get some people to buy that service. We'll have an anti-registry. We'll have anti-activities you can do. It's like, we could do things out now. It's like, whatever. I'm going to create a website. Yeah.
Forth, right? So what speech is being, that's what websites do, just like it's what invitations do, right? So, next we'll have the stationer up there saying, we print the stationery, right? That would be the same. It is announcing the wedding. What's the speech that's been required of your client that I'm going to have lots of questions for these guys too, but in that context, what is the speech that is required of your client that would violate the First Amendment?
She believes that same-sex weddings contradict Scripture, and she's announcing a concept of marriage that she believes to be false. And in addition to that,
but that just sounds to me like I would be participating in a wedding. I would be, lending my services to a wedding. As Justice Sotomayor suggested, the florist, the baker, and the guy who provides the chairs are also providing the services in a wedding that they don't like. So why are they any different?
The person providing the chairs isn't providing speech, but when you are engaging in symbolic speech, whether that be through the creation of a custom wedding cake or a custom wedding website, you are creating speech.
Even though the site doesn't say anything about that. It doesn't say, wow, gay marriage is a wonderful thing. It doesn't even say, we're here to celebrate this wonderful marriage in my hypothetical. It doesn't even say that.
Again,
Maybe I could go to them for a wedding for myself, a wedding site. Pleased to announce the engagement of Uncivil Law and party to be named later. Is that too much for a dating website? We have my arm around a woman with my arm around a woman and replace her face with a white oval with a question mark on it. See, this could be you. Apply now. Get a graphics designer to design that. Announcing the wedding between Uncivil Law and it could be you. Oh man, this is too good shit. All right, yeah.
The announcement of the wedding itself is a concept that she believes to be false, and the entire purpose behind the compelled speech doctrine is to avoid these ends by avoiding these beginnings. It's to ensure that individuals don't speak messages that betray their conscience, and that applies just as much to the Democrat as to the LGBT or the Black cross sculptor.
Thank you.
Thank you.
Justice Gorsuch?
So, counsel, we've spoken a little bit about how Colorado has handled this compelled speech question differently with respect to different messages, some that it prefers, others that it dislikes. I'm curious how other states have dealt with this conundrum besides Colorado, and which ones of those you think we should take account of.
20 states filed an amicus brief in support of Ms. Smith and expressed to this court that they're applying their public accommodation law to provide message-based protections, just like the court did in Hurley, following the same test that's being articulated today. And they've been doing it successfully. Yes, there are difficult line-drawing questions, but those are in every speech case, whether it's sleeping in the park or putting on an armband. The court doesn't have to resolve every single one of them, but we do have the rules, and we need the court to provide guidance. Again, reaffirming public accommodation laws cannot compel speech creators, whether that's artistic expression with symbols or pure speech.
And just so I make sure I understood your colloquy with Justice Barrett, the objections to compelled speech here on religious grounds could include, in fact, do include some objections with respect to certain heterosexual marriages. That there are certain heterosexual unions that your client would not speak toward either. Is that correct?
Certainly, and that's in the stipulated facts in terms of she declines messages based on the message, and she has declined other projects based on the message that have nothing to do with same-sex marriage.
So the question isn't who, it's what.
Always.
Thank you.
Thank you.
Justice Kavanaugh?
From the briefs, I saw a lot of agreement, actually, between the parties in this case on basic legal principles. In your reply brief, page 15, you say that hairstylists, landscapers, plumbers, caterers, tailors, jewelers, and restaurants ordinarily wouldn't have First Amendment free speech right to decline to serve a same-sex wedding. At least that's how I read that reference in your brief. But you say artists are different, like publishing houses. And I think the other side, I'll hear from them, but agree that artists are different because of the First Amendment rights that artists possess. But then, at least as I read the briefs, the case comes down to a fairly narrow question of how do you characterize website designers? Are they more like the restaurants and the jewelers and the tailors, or are they more like the publishing houses and the other free speech analogs that are raised on the other side? That's what I took away from the briefs. A lot of agreement on broad legal principles and some disagreement about how to characterize the website designers. So why are you right about how you characterize website designers, or put another way, why are they different? And you've gotten this question, why are they different from, say, restaurants or caterers, for example?
Because they're creating speech. In those other examples, speech is not at issue. That is creating speech, announcing a wedding or announcing anything. And art is different. And so while there may be agreement on that, there also is a problem with Colorado's advancing theories that keep narrowing and providing alternatives. But in the end, one thing is certain. Those who object to same-sex marriage and creating messages about them, those are the ones that can't speak. But everyone else seems to be able to do so under Colorado's theory. In addition, this court has already articulated how we determine whether speech is involved for an artist. And I think the court could follow those tests here with words, graphics, videos, and again, symbolic speech.
So for you, as there's a effort to protect both the equal rights of gay and lesbian people and same-sex couples at the same time protect free speech rights, your line is look at whether the action of the business involves speech.
And the second line would be to look at what is the objection that the creator is asserting, and would that actually be in the final product, because that's how this court has ferreted out pretextual objections. So if a speech creator articulates an objection and it's not in that final photograph, the objection or the message isn't in there, that's one way we can know. Another is if they're refusing to serve an entire class of people and design other messages, none of which are true here. But
so if you win this case, if you prevail here, and the next case involves a caterer, at least your position here is that's different.
I won't be coming back with the caterer, but I will be coming back with perhaps a custom wedding cake or a cake that has a symbolic meaning to it.
Okay, but the caterer, the list of things that you had on page 15 of the reply brief, at least ordinarily, you had a caveat in there, but ordinarily wouldn't have the same right that your client here does who's a website designer.
They wouldn't have a free speech right. And as in terms of your initial statement about the parties agreeing, I do think it's important on pages 17 and 32 of the United States brief, they're even conceding that it's a burden on a speaker to have to express a message that violates their convictions. They're just simply relabeling this or repackaging speech as a sale or conduct.
Thank you.
Justice Barrett?
So I think the questions that Justice Kagan asked you are hard because they seem like they're not creating. I mean, you're on your strongest ground when you're talking about her sitting down and designing and coming up with the graphics to customize them for the couple. So let me just clarify exactly what your position is on things that are already created in the past. What if it is plug and play? I don't know that much about website design, so I don't know how it could be plug and play. I'm sure it can be. She does the programming, the coding, she has stock pictures, and she sells that as a product, and the customers, Mike and Henry or, Lily and Luke fill it in themselves. Is that protected?
It is not protected in the same way that if you sold a Bible commentary, you wouldn't be able to decide whether the Bible commentary will be burned or it will be used in a church service. The stream of commerce, it's been put in the stream of commerce.
Okay, so why is it different? Justice Kagan said, so maybe you do create customized websites and you've created one for, Lily and Luke, and then, Mike and Henry see it and say, you've created that already, we love it. We want to buy it. Don't create anything new for us. Just give us exactly what you did for them. Why is that different than plug and play, or is it?
It is different. I mean, first of all, if I take your hypothetical on its face, we would be selling essentially she would be creating a website that's exactly the same with the same pictures and text and graphics and videos of an opposite sex couple and selling it to a same sex couple, which seems highly unlikely. They wouldn't use that to celebrate their wedding. So in terms of if you're asking her to change the text, to change the logistics, to change the names, you're changing bride and groom. You're changing the couple's name. We know context changes meaning. Justice Ginsburg said that in Yates versus United States. Even the same words have different meaning. God bless this marriage means something different. My body, my choice means something different to an anti-vaxxer or a pro-abortion opponent or proponent.
Nice.
So in that sense, that's why she would object if she were changing the words in the text. But of course she would sell the same website celebrating an opposite-sex wedding to a same-sex couple.
Okay, so context changes meaning. What if instead of a graphic designer, she's a songwriter? And she writes a song, let's say At Last or Wind Beneath My Wings or something that people want to dance to at their wedding. And the lyrics are out there, it could be played at a heterosexual wedding or it could be played at a gay wedding. Once the artist has created that song, can the artist say, but I'm not licensing it to be played at certain kinds of weddings?
No, I don't think the artist could. I'm not familiar with the licensing rules and how all that would apply in terms of the contractual relationship. But in terms of just having a song used at a wedding, assuming that would otherwise be okay, there's no other legal rights, she couldn't. That was in the stream of commerce. But I think it's important to point out that if that artist were being asked to perform that song in a live way, for example, sang at a Democratic inauguration and they were asked to perform at the Republican one, under Colorado's theory, they could be compelled to do so in a number of jurisdictions. 19 jurisdictions have political ideology. And when we think about that, there's no limit to what the government could compel.
Thank you.
Justice Jackson?
But isn't an artist typically sort of a freelancer and they are selling their own messages? They're not purporting to be a business for hire in any meaningful sense. And so I want to kind of go back to Justice Kavanaugh's thought of, like, where do we place your client as between, restaurants and artists? I thought that there really isn't that clear a distinction in a situation like this, because your client is an artist for hire, essentially. Yes, she does customize things. They're not off the shelf, but she purports to be a public accommodation providing customized things to anyone who pays her, except for people whose messages are those that she disagrees with. And I just don't know that I've ever seen that kind of scenario, even in the cases that you're talking about, because sort of what Justice Gorsuch was saying, it's relying on the implicit message that she does not want to convey by supporting this person. There's an explicit message in the actual work, but to the extent that actual work is identical to the work that she would otherwise sell to the gay couple, except for their names, then she is implicitly saying, by selling this, I'm going to be violating my own beliefs. So let me just ask you another quick hypo. So I'm trying to understand the extent to which this matters that she's a speaker as opposed to a restaurant. So I sell food, and one line of products that I make is from scratch for particular customers that are based on my grandmother's cherished family recipes. My dearly departed grandmother was clear that she only wanted to provide this kind of nourishment for people who share our same religious heritage. So I call these products Grandma Helen's Protestant Provisions. And I sit with each customer who comes in and I hear about their faith and their family, and I customize the recipe for them after having this discussion. So the food is not expressive, right? I'm not speaking in my food, but I am trying to convey that only certain people get to partake in this product. Can I do that consistent with the First Amendment or not?
No, and in the situation, as you said, in terms of a caterer, the caterer is not engaging in speech. In terms of your initial statements or questions, speech is speech, whether it's paid or pro bono.
But don't we have cases that suggest that people's conduct can be expressive? I thought there was a whole line of cases that said you didn't have to actually have an express message. You could be acting in such a way as to express a message. And in my restaurant hypo, I'm saying if I sell to non-Protestants, I'd be expressing a message contrary to Grandma Helen's core beliefs.
You're speaking through conduct at that point, and that is a different analysis. In terms of the expressive conduct test, the court has already articulated what those tests are and what a reasonable person would observe. But in that case, you're talking essentially about status discrimination. There's no message that she is creating that would be compelled in that way. That would simply be service. In addition, though, I think it's important to recognize the breadth of the public accommodation law. You've started with a statement about freelance writers. At oral argument at the 10th Circuit, my friend in Colorado admitted that freelance writers are considered to be public accommodations under this law.
All right, well, I'll ask them about that, but what about my photographer? My photographer is speaking through photography, yes?
In your photography, yes, photography is speech, just as websites are under the court's decision in Reno.
All right, so my photographer is speaking by being forced to create a Santa photo with minority children in it that they don't want to. They don't think that should be there.
The issue in that hypothetical isn't whether there is speech. The issue is, in that context, are they otherwise serving those and expressing other messages, and does the objection that they're asserting line up with the message? The court in Hurley did the exact same analysis to say, is the parade organizers otherwise...
But Hurley was a private association. It wasn't a public business. What I'm asking you is, I have a public business. I'm a photographer. My belief is that, I'm doing It's a Wonderful Life scenes. That's what I'm offering. Okay? I want to do video depictions of It's a Wonderful Life. And I, knowing that movie very well, I want to be authentic, and so only white children and families can be customers for that particular product. Everybody else I'll give to everybody else. I'll sell them anything they want, just not the It's a Wonderful Life depictions. I'm expressing something, right, for your purposes. That's speech. What about, what's the other step? It's speech, and I can say anti-discrimination laws can't make me sell the It's a Wonderful Life package to non-white individuals.
In the same way, I would say, first of all, in the same way that this court, when there is a message and a status and it's overlapping, the court would say that message wins in that instance. So I don't think that
I don't have to sell it to white.
I don't think that message is in that hypothetical, but take the example of the musical of Hamilton. There's a direct overlap in the musical of Hamilton, and in that case, we know that they're expressing a preference for who they're hiring in terms of race.
No, I'm not talking about, you're sort of slipping into it like 1,000 different analogies. I just want you to focus on whether or not I have speech when I am a photography business and I hang out my shingle, everybody can come, but I have certain products that I'll only sell to to white individuals because the speech that I'm trying to depict is the authentic depiction of that scene as I understand it and that I want to put out there in the world. And it has my signature on the bottom of it, so people are seeing my photos. And I want my photos of It's a Wonderful Life to be as authentic as possible, meaning no people of color.
It seems in each iteration of the hypothetical, the objection is changing. What I can articulate is the test, and I can also say that when there is an overlap between message and status, message does win, and Hamilton provides an example of that.
All right, thank you.
Thank you, counsel.
I think this has to be the right answer in the end. I mean, it's not the First Amendment trumps. The First Amendment trumps. The First Amendment is the right of freedom of speech. The freedom of speech is the right to say things that say good things, say bad things, say just things, say unjust things. It's a right to speak one's perspective, for better or worse. The ACLU, of course, very famously went to bat for the Nazis in Stokey, Illinois, because of this, right? The right to freedom of speech is the right to say despicable things. The ACLU defended the Nazis and said, you have a right to march. Your vile speech. Right. Because that's the nature of the First Amendment, is the right to say vile things. And to not say vile things. Because you're in control of your speech. And the government can't compel people's speech, particularly people's creative speech. And so, like, Justice Jackson over here, the one thing I don't really like about this advocate as much is that she's a little bit fighting the hypothetical, and I don't know that she needs to. Like, she's not just answering the question. She's fighting the hypothetical a little bit. Like, if I were in this position, I'd just be saying, yes, the photographer can do that. The photographer can, in fact, if he's interested, it's a creative expression. The case law is clear. The photographer is the one that's creative. That's the reason that they're the one that gets the copyright. The person who creates the photograph is the copyright holder because they're the one that has the creative expression. To create the photograph is the creative expression. If they want to create a creative expression in a particular way, who is in the scene and the races of the people in the scene may very well matter. Right? It's because it depends on like what they want to say or what they don't want to say. And people have done, Shakespeare every possible way, all black casts, all white casts, all women, all men. I mean, they've done Shakespeare and every possible recombination known to man, for example, right? So because based on what the person is wanting to say. The Lion King, they did it with animals one time. That was Hamlet. But, whatever. Anyways, but that's the nature of the First Amendment. And the only thing I don't like about this advocate is she's finding the hypothetical. Because I just answer the hypothetical, be like, if it's speech, yes. Now, there is case law dealing with speech that's incidental to non-speech, right? So this is the thrust of the case law. So it's like, okay, does this principle that I'm reaching for extend to, for example, this field or that field? And the answer is no. The answer is no, because even though there might be some speech in some sense, it's incidental to the overlying thing, right? So this is maybe Ollie's barbecue, to take a point. This is Ollie's barbecue. It's like, okay, I'm sending a message by allowing Black people to be inside my restaurant. That was Ollie's barbecue. I didn't want Black people in my restaurant. I only want to give them takeout. They can't sit down, but I'll serve them outside the window. Okay? And if I let them inside, that's sending a message. Well, the overall thrust of the case law is that if the speech is incidental, then it's not a problem. And so what you're doing is barbecue. That's what you're doing. So any speech message is so incidental, so attenuated from that this is not a problem, right? But here, this is kind of the exact opposite. So this case is in some ways a mirror opposite of Ollie's barbecue, right? In Ollie's barbecue, it's like you're doing barbecue. Speech, to the extent it exists at all, is a dream of an afterthought. This case is kind of the exact polar opposite of that, because this is dealing with pure speech. This is dealing with creation. She's a designer. She's creating a creative work, or the photographer, or whatever, like the photographer, the writer, the person who's actually creating this. And so if they want to discriminate on the basis of any category at all, then they can, because that's the nature of the First Amendment. The civil rights law, and in fact, for that matter, all law must bend to superior law. So the Civil Rights Act and Anti-Discrimination Acts and Title VII and Title IX and Title VI must all necessarily bend to the Constitution, because the Constitution is, by its own design, the supreme law of the land. That's what the Constitution says. So the Civil Rights Act must bend. The Title VI, Title VII, Title IX must bend. Non-discrimination law must bend. It all must bend to the First Amendment principle. And then, of course, we might have to get into the issue of, okay, if we say that Ollie's barbecue is on the one end of the extreme and this is on the other end of the extreme, where is the middle ground? And that's often a question in law, but we have some case law to deal with that already, because this is not the first time someone has tried like a freedom of religion, freedom of association, or even freedom of speech case with respect to non-speech things. So there are things that are on the continuum of speech. We've already have a lot of case law dealing with that, so we don't have to create it for the first time. But if we're in this pure speech context, then the answer, I think, that the advocate should have given is yes, the photographer can do that. If the photographer's vision is, I want to only create scenes from It's a Wonderful Life, and so I only want to have white children in my scene because that's my vision, then so be it. So be it. That's that photographer's creative speech. That's the speech he wants to create. And then other people can have other views about that. Other people can be like, well, that's stupid because he's turning down money, and I like money. As long as it's green, baby. So I'm going to open a rival photography studio, and anyone who wants to come by can do this, right? So that is in the nature of free market competition. It also would allow people to say, hey, that guy is a racist because, he's not doing XYZ. They're already saying that anyway, but I mean, that's in the nature of freedom of speech, right? So the one criticism I have of her is that she, I don't know what this means, for example, about a tailor or, some other professions. I don't know what that necessarily means, but we're in this pure speech context. And so, yes, I think what the advocate should have said is yes, the person can do that. If we concluded that this is speech using the relevant tests, this is speech, not incidental to it, this is speech, regulation of speech, then we're into the subject matter or viewpoint matter, because what we're telling the artist to do is you must film using black children or white children, as the case may be, which is a viewpoint or subject matter based regulation, which is strict scrutiny, which is basically impossible. And as always, it allows people to be assholes. That is the nature of the First Amendment. The First Amendment allows people to be assholes. And then other people can be like, hey, that person's an asshole. And it allows people to open competing businesses that aren't asshole-ish. So this is my one criticism of her. It's like, is it good? Is it good that the photographer cannot take photographs of the black children who want to be with Santa Claus in the It's a Wonderful Life, May You? Well, morality and law are often not the same question. So whether it's good or not, it is the law, in my opinion. And so if I had to give one the problem is she doesn't want to accept the consequences of her own argument, and I think she should. Right? Sometimes you got to hedge because for a whole bunch of reasons, but I don't think this is the time you should hedge. I think the right answer is yes. I think yes, the answer is this website designer can in fact refuse to design a website because they're handicapped, because they're interracial, because they're gay, because I don't know, whatever reason they want, literally any reason they want, because that's in the nature of the First Amendment. Because the only way to overcome that is strict scrutiny, and that we can't do that. There's no way to get there. So that's my criticism of that. But I think that's the right First Amendment answer in the extreme case that we're talking about, in this pure speech case. And then again, we could have the fight about the middle ground, right? But we know the answer in the pure speech case. We know the answer in the Ali Barbecues case. And so then we'll have a bit of a fight about where it is in between. But that's okay. That's what we do sometimes. Okay, let's listen to some more argument. We are 52 minutes into this. We got 2 hours, 20 minutes total. So that leaves us with about an hour and a half left. Let's listen to some more.
Mr. Olson?
Mr. Chief Justice, and may it please the court. The central dispute here is what public accommodations law targets when they require a business to provide equal access to its services. The company claims that because it wants to sell websites, the law somehow targets expression and therefore violates the First Amendment.
Yeah. Because it wants to sell websites, the law somehow targets expression. A little bit.
But because Colorado law targets the commercial conduct of discriminatory sales, and its effect on expression is at most incidental, it easily satisfies the framework set out in O'Brien. The company can choose to sell websites that only feature biblical quotes describing a marriage as between a man and a woman, just like a Christmas store can choose to sell only Christmas-related items. The company just cannot refuse to serve gay couples, as it seeks to do here, just as the Christmas store cannot announce no Jews allowed. Here, the company...
But the Christmas store isn't typically providing custom stuff. And if it was, we'd be in the same analysis as far as I'm concerned.
Seeks a pre-enforcement order, allowing it to turn away all gay couples, even if, as we've discussed, the wedding website they request is identical to one the company would sell to a heterosexual couple. Granting such a license to discriminate would empower all businesses that offer what they believe to be expressive services, from architects to photographers to consultants, to refuse service to customers because of their disability, sexual orientation, religion, or race. The free speech clause exemption the company seeks here is sweeping, because it would apply not just to sincerely held religious beliefs like those of the company and its owner, but also to all sorts of racist, sexist, and bigoted views.
Yes, I will quibble with you on the first part of your premise. All businesses that offer what they believe to be expressive services, from architects to photographers to consultants, I don't think that's true. We already have some case law dealing with that, because again, this isn't the first time a business has tried to say their discrimination is justified by the First Amendment. and Ollie's Barbecue perhaps is the extreme case, or maybe Heart of Atlanta Motel is the extreme case. But like either way, it's whatever the extreme case, whether it's Ollie's Barbecue or Heart of Atlanta Motel. In those cases, whatever speech interest might exist, if it exists at all, is so removed from the activity that it's not what's being regulated. And so that's okay. We've got lots of case law dealing with that kind of stuff on that extreme edge. And now we've got this case law presumably dealing with this on this extreme edge, on this other extreme edge, right? So this is about as pure speech as one can imagine, because it's a website and it's words. And so that's basically speech. So I think I would question the first part of his conclusion that it would empower all businesses to offer what they believe to be expressive services, because we could get into the distinction that the case law supports between whether it's really expressive or not. And there might be some cases somewhere in between where it might become a little nebulous. But then again, that's boundary drawing, and we do that in law all the time. So, fine. But taking the premise and ignoring that for the moment, the conclusion would be correct. Whatever businesses it extends to, with respect to whatever services it extends to, whatever the limits of this thing are, because that's the question we would be asking, right? We already know Ollie Barbecue. We already know Heart of Atlanta doesn't extend. This would be the new one. So it would extend here and to whatever else it would extend. Then the conclusion is correct. The free speech clause exemption is sweeping because it would in fact apply to sincerely held religious beliefs, racism, sexism, bigotry, and literally everything else on the face of the earth, because that's the nature of the First Amendment. That's the nature of the First Amendment, because religion is religion. Racism, sexism, and bigotry is viewpoint. And we already know how we deal with discrimination on the basis of viewpoint. It's strict scrutiny. And we don't compel that speech. So it wouldn't allow all businesses to just magically say, oh, I'm an expressive service. It wouldn't do that. That's wrong. But whoever would be covered by it, and 303 would be covered by it, in this context at least, it would extend to all these things because the First Amendment allows vile things. And the ACLU used to know that when they used to defend the Nazis at Stokey. The ACLU, the freedom of speech is the freedom to say racist, sexist, and bigoted things. So, yeah.
This rule would allow another web design company to say, no interracial couple served. An ad agency could refuse women-led businesses. And a tech consulting company could refuse to serve 303 Creative itself because it disagreed with the owner's religion. This court should.
So you'd have an easier time with the first one. An ad agency could refuse women-led businesses. The ad agency is more speech. The tech consulting firm, less so, given the case law that already exists. So his conclusion, his premise is wrong. His premise is wrong. His conclusion is correct. But it's oversweeping. So would it allow the ad agency to refuse women businesses? Yeah. Would it allow the tech company to refuse 303? No, because the speech is incidental, and we have case law for that proposition.
Not upend long-settled law that protects the full and equal access of all Americans to our public marketplace. I welcome the court's questions.
Counsel, you have spent quite a bit of your brief talking about the tradition of public accommodations laws. Would you just spend a few minutes or whatever amount of time you can explaining whether there is a similarly long tradition of public accommodations laws applying to speech or expressive conduct?
Well, certainly, Justice Thomas, the history of public accommodation laws shows that when those held themselves open to the public, they were required to serve everybody.
I understand that. The complicating fact here is this is not a hotel. This is not a restaurant. This is not a riverboat or a train. I'm interested in the intersection of public accommodations law and speech.
I think we see some public accommodation law being applied to examples that are speech today, tailors, barbers, etc. But what we don't see over the long history of public accommodation laws in this country is people raising First Amendment speech objections to those laws applying to it.
Well, I think that in part depends upon whether or not you're engaging in speech. If you're running a train business or a riverboat business, that's not exactly, doesn't implicate speech.
Yeah. Or a hotel or a barbecue restaurant, right? So, yeah, if you're running a train or a riverboat or a hotel or a barbecue restaurant, whatever speech concerns are in the nature of that business, to the extent they exist at all, which is debatable, are so far removed from the business that no. So, right.
So those are straightforward. I understand that. What I'm interested in is when you are talking about public accommodations laws directly or indirectly regulating speech, is there a tradition of that? Can you point to cases? Can you point to common law treatises, etc.?
So I think that the historical record is sparse on both sides, but the two things I would say, Justice Thomas, is what we don't see is a history of public accommodation laws carving out speech. They all are laws of general applicability that apply to all those operating a trade to the public. They don't say except those engaged in expressive conduct. And with that framework, we do not see a history of cases where people raised their hand and said it shouldn't apply to me because I'm speaking. And so I think the public accommodations brief on our side in this case sets that out quite nicely. But there is no case from 150 years ago that comes out either way with this exact issue.
Mr. Olson, I'm sorry, Chief.
Not 150 years ago, but I think it's 10 or 12 years ago in City of Fulton, which you cite in your brief. It sort of follows up on Justice Thomas's question, although you don't even get to speech. I think the court in that case said, when you're looking at some of the concerns that you're talking about, that a individualized, subjective, multi-factor, whatever determination, in that case foster care and adoption, is not the same as a seat on the bus or a room in the hotel. How does your argument fit with that position that was articulated in the court with respect to the nature of individual speakers' message?
Well, I think those questions are not presented in this case because most artists are not public accommodations, but my friend stipulated that the company was a public accommodation, and often a lot of the hypotheticals that we've been talking about artists and certainly Lin-Manuel Miranda, who is writing the play Hamilton.
In terms of the concern expressed in a lot of our cases about compelled speech and the distinction of others where you can have a requirement of serving people without regard to certain characteristics. The case did make the point that to the extent there's subjective, individualized determinations that go into the decision about placing children, that those cases were not, at least not directly applicable.
That's correct, Chief Justice Roberts. And I think here, again, the record is entirely devoid of those factors because the company chose to litigate this case as a public accommodation. I think a lot of the description that we heard today would be powerful arguments that they may not be a public accommodation in what they do, but we simply don't have those facts here. But certainly the level of selectivity, the way in which the potential customer engages with the client, with the service provider, and how the service provider makes their product available or known to the public, all factor in that analysis.
I'd like to ask you a question about one other case. It's the one you rely on most heavily in your brief, Rumsfeld against Fair. And it seems to me that a distinction you have to deal with in that case is that the speech there was not compelled, or what was compelled was not considered speech. It involved the schools providing rooms for the military recruiter. And when it came to the question of compelled speech, what the court said is empty rooms don't speak. But here, of course, the whole argument is that the speech is being compelled. So how does the either holding or analysis in FAIR help you?
Two responses, Chief Justice. First is, in FAIR, recognize that there was some speech by the schools. There were emails, posters on bulletin boards, et cetera. So there was some speech, but it said it was incidental, like in O'Brien, to the purpose of the regulation, which was ensuring equal access, similar to Colorado's law here. And the second point,
incidental speech. Incidental speech. Right. So, like, again, is there a speech component there? Maybe, but it's incidental. That's the overall thrust of the case law. And this is not incidental. This is speech. The speech is not incidental in anything. It's a website design. It's pretty speech oriented. So again, the parade of horribles about who this would impact is not necessarily. This would impact creative industries, speech, and beyond that, I don't know. And how many people would actually take advantage of this is a question, because they would lose business, and it would be bad for business. And Green speaks pretty loudly, so but to the extent it does exist, it does allow people to be assholes.
I would make, and it comes from the example of the identical website being turned away for the same-sex couple but provided to the opposite-sex couple. Here, sometimes the speech itself does not change. And what this company seeks, if you look at the specific prayer for relief in the complaint, is a total permission to turn away every same-sex couple, even if they seek exactly the same website that an opposite-sex couple that they would provide.
Just to stop you, their point is they do not turn away same-sex couples who want the service that they're providing. They just won't provide that service with respect to a particular type of wedding.
I respectfully disagree, Your Honor. What the company said is under no circumstances will they provide a wedding website for a same-sex wedding. Period.
Correct.
Right. And that is status-based discrimination. And it doesn't matter whose credit card is used for that transaction. What the sole basis that the company seeks relief from this court is they would like an injunction that says, so long as if this is going to be used for a same-sex wedding, then we need not provide it. And so it's a status-based discrimination that they seek from this court.
Even if it is a status-based discrimination, the status is in the nature of the speech. They might be inseparable. She says I'm discriminating based on the speech, not the status. He says it's status. Maybe they're inseparable. If they're truly inseparable, though, then the First Amendment wins. Because if the argument is that their status is inseparable from speech, then their status is itself speech. That would be the nature of being inseparable, right? That'd be the nature of it being inseparable. If it's truly inseparable, if their status is truly inseparable from their speech, then their status is the same as speech. So their status is speech. If it's inseparable, that's logical. That's a logical necessity. So it's like, well, if you want to say their being black is itself speech because it's inseparable, so it must be, then I guess the First Amendment must win. Because freedom of speech. So I don't know that I would say that their speech is inseparable, but that's your argument. I'm just following it through to its logical consequence. So, I mean,
Let me see if I understand your argument. I understand you to be arguing that a website designer can put anything it wants on a standardized website, even if that includes a denunciation of same-sex marriage. Is that correct?
Yes.
So if, to pick up on Justice Kagan's hypothetical from earlier this morning, if the standard announcement is made with love by Amber, who believes that a valid marriage is a union between one man and one woman, that's okay.
If that's on every website, yes.
I mean, your argument is, you're making kind of a sliver of an argument, right? What is the difference between that and what you think is a violation of your law?
Two things, Justice Alito.
That website designer is not going to be serving a same-sex couple if the website designer puts that on the website. They're turning away same-sex couples by doing that, are they not?
They're not turning away same-sex couples. They are they are able to choose what services they offer, and that is the service they're choosing to offer. The state does not regulate that at all. All that the state says is whatever you choose to sell.
No, I understand that. Does it make any difference in the real world as a practical matter?
It does in the real world, because my second point is that a website designer like that will lose a lot of opposite-sex couples as potential clients as well, because they don't want to be seen with that message. And what the company wants to do here is take advantage of the public marketplace, of go out and sell their...
I would imagine word about 303 creative enterprises might get out. I don't know. I'm just having a sneaking suspicion that 303s, even if 303 can't put on its website, we believe that marriage is between one man and one woman. I'm guessing some people might learn that about 303. And I'm guessing that some people might understand that it's 303's position. I'm suspecting that some people may make 303's position on this issue somewhat clear. I'm not sensing that there's going to be a lot of trickery afoot, but okay.
Wares to everyone and have control over and change what they sell to different people based on the status of what they have.
Okay, yeah, I understand that. So to sell to everyone. So this goes to the interpretation of your statute, and I'm not quite clear what your position is on it. If a business provides a service that is, quote, open to the public, it's a public accommodation, right?
Yeah, you have to engage in sales or offering services to the public, yes.
Okay. So what does open to the public mean? Does that mean no selectivity whatsoever? Anybody who wants this service can get it, and maybe if there's a greater demand than the demand exceeds the supply, you've got to wait in line. But if there's any selectivity at all, they're out.
Well, again, it's not presented in this case. The way that Colorado has historically addressed that question are, say, golf clubs who had limited their membership to one gender. Did they make money from public coming to their courses? Did you have to be a member to dine in the restaurant, et cetera? So selectivity, as the court discussed in Fulton, certainly is a factor, but it is a fact-specific determination that awaits more facts than we have here. Because
well, you should understand what your statute means. So if suppose a website designer says, I'm offering my services, but I'm in a lot of demand for my services, and I reserve the right to decide who I will provide a website for and who I will not. Is it a public accommodation then?
If that's the only factor, then yes, but it can make decisions about who to supply that aren't based on protected characteristic and choose its clientele just fine. What it can't do is say, I reserve the right to refuse service, which means in practice I will not serve black people.
And isn't part of the problem here in terms of trying to answer Justice Alito's various hypotheticals that were presented with a record of stipulated facts, and that your friend on the other side actually stipulated to the application of the statute? So it's really hard for us to know and figure out and determine in this context how the statute would actually apply, because we don't really have a real record on that score.
That's an interesting proposition. So this is all stipulated facts, right? Because it's a pre-enforcement challenge, which again is not unknown to law, especially in a First Amendment context. And she's like, well, we don't know how it would actually apply because they've only agreed that it would apply. So we don't know how it would actually apply because we don't have a record because they agreed it would apply. So they don't dispute the facts. See, that's the nature of the stipulated fact. They agree on the facts. So it's like, it's really hard for us to figure out how the statute would actually apply, except for the fact that the parties say it would. Okay, all right.
That's correct. And I would say that we've heard some discussion from my friend about sort of Colorado's history, but what we haven't heard is any specific example since this court announced Masterpiece of Colorado enforcing this law, the state enforcing this law against anyone.
Well, my question really was not whether this website is a public accommodation. I understand that's been stipulated. That wasn't my question. What I'm trying to understand is the breadth of your argument. And what I get is that you're making a tiny sliver of an argument. So the website can put anything on its website, even something that will blatantly or subtly tell a same-sex couple, well, this is not a service that I want. They can do that. And the website can also potentially get itself out from being a public accommodation simply by reserving a degree of selectivity. That's what you've told me so far.
No, I don't think it's just by reserving a degree of selectivity, but I think the more selective and sort of curated the process is, it makes it less likely to be a public accommodation, as the court recognized in Fulton.
All right, let me ask you, and then I'll finish this line. Some hypotheticals.
Josh Blackman is a pretty smart guy.
A brief submitted by Josh Blackman. A Jewish man and a Jewish woman who were engaged to be married ask a Jewish website designer to build a website to celebrate their their nuptials. No problem. Okay. Another Jewish man and a Christian woman who were engaged to be married ask a Jewish website designer to build a website to celebrate their nuptials. Big problem. Quote, many Jews consider intermarriage an existential threat to the future of Judaism. Does that website have to accept the second couple?
Again, as we talked about before, if the Jewish website designer has, very explicitly Jewish themes on the wedding, they don't need to on the website. They don't need to take that down for the interreligious couple that comes. But if they offer a general service to the public, they need to offer that regardless of the customer's religion.
So the fact that they offer this that this is a Jewish that is offered mostly to Jews, that's enough to make it, or exclusively to Jews, that's enough to make it sufficiently selective to get them out from your...
No, I'm drawing a distinction between what the website designer chooses to put on the website and who the website designer sells the website to. The website designer can choose to put on their websites whatever they want, but they just can't refuse to sell, if they're a public accommodation, they can't refuse to sell that website to someone solely because of their customers or the couple's religion.
Okay, an unmarried Jewish person asks a Jewish photographer to take a photograph for his J-Date dating profile. Is it a dating service, I gather, for Jewish people?
It is.
All right. Maybe Justice Kagan will also be familiar with the next website I'm going to mention. So next, a Jewish person asks a Jewish photographer to take a photograph for his AshleyMadison.com dating profile. I'm not suggesting that. I mean, she knows a lot of things. I'm not suggesting. Okay. Does he have to do it?
Well, again, it would, what Colorado it depends. What Colorado looks to is what services the photographer makes available to the public. And if the photographer makes that service available to others taking pictures, for use on websites, then probably yes. But it depends on.
Okay, Justice, then I really will stop. Justice Jackson's example of the Santa in the mall who, doesn't want his picture taken with black children. So if there's a black Santa at the other end of the mall, and he doesn't want to have his picture taken with a child who's dressed up in a Ku Klux Klan outfit. That black Santa has to do that?
No, because Ku Klux Klan outfits are not protected characteristics under public accommodation laws.
And presumably that would be the same Ku Klux Klan outfit, regardless whether if the child was black or white or any other characteristic.
Yeah, you do see a lot of black children in Ku Klux Klan outfits, right? All the time. Suppose that
Can I?
Yeah.
Yeah. Is that all right?
Sure.
I have one, I hope, easy question for you, and then a more difficult question. So, As I understand your argument, the kind of you can say anything you want as long as you say it to everybody, or not say anything you want as long as you don't say it to anybody. So gay couple walks in to Ms. Smith's office and says, we want a quote from Obergefell. And she says, I don't do that. That's okay with you, yes?
Yes.
Because she doesn't do it for anybody. Yeah?
Correct.
Okay. Gay couple walks in and says, this is the harder one, all right? Gay couple walks in and says, I'd like the standard website, everything's standard, the kind of website we were talking about before, but I want something in addition to that. I want on the home page, the website to say, God blesses this union, all right? And Ms. Smith says, that's a problem, Ms. Smith says. And the gay couple says, well, you would say that if we were an opposite-sex couple, right? And she says, I would say that if you were an opposite-sex couple. And the gay couple says, well, what's the big deal then? I don't know. I think that kind of is different. So I'm wondering whether you think it's different.
Well, I think it's different in part because it implicates the very compelling free exercise concerns of the vendor, which aren't present in this case, right? This is just a
possible. I get the idea that there's a kind of religious element to it. And I wish I could think of one that didn't have that component, because I feel like there's something else going on there as well, that it is a statement of opinion about the nature of this marriage, which, in my earlier hypotheticals, I took care to remove. But now there's a kind of statement of opinion about the nature of this marriage. And unlike the kind of our story things, which is like, obviously, it's their story. It's not the designer's story. Unlike that, it feels a little bit to me as though it could be a kind of third person saying God blesses this union. And who would the third person be other than the person who's put the whole websites together?
Okay.
Together. So I have difficulty with that hypothetical, and I'm wondering what you think about it.
So I agree, Justice Kagan. And I think, imagine a statement that says something along the lines of, there's a dating website that meets people, and then the people that they connect through that says, this is a wonderful marriage that we support. No religion, right? And then where you have that direct speech, it does get a little trickier. But what I would say is, this is, the default rule would still apply, even though that is an edge case. I agree, because the question is, what services does the company choose to provide? And if it chooses to provide that service to some, now here it's, it may be that looking at the service is, well, I evaluate your marriage and I give it a thumbs up or a thumbs down, and assume you don't want the thumbs down on the website. So if you get a thumbs up, you get on the website. So that's a fact question. I think that would be hard. But if it was a statement that was made solely based on the status of the person seeking the website, in other words, thumbs up for all opposite-sex couples, thumbs down for same-sex couples, then it's an easier question.
Thank you, counsel. Justice Thomas?
Poor Justice Roberts trying to keep some sort of civility going here.
Anything further? Justice Alito?
Well, back to my Black Santa example. Suppose it's a state that defines prohibits a public accommodation to discriminate on the basis of political ideology. So then the picture has to be taken.
I think that is likely. Those political ideology distinctions face much more difficult constitutional scrutiny, and I think are separate in kind from the kind of characteristics that we're talking about here, which are categories of invidious discrimination. I candidly think in most circumstances political ideology did not satisfy the constitutional requirements.
So it has to satisfy a constitutional requirement. Your argument is dependent on that.
Yes. Because even under O'Brien, we have to show a basis for what we're doing.
In light of what Justice Kennedy wrote in Obergefell about honorable people who object to same-sex marriage, do you think it's fair to equate opposition to same-sex marriage with opposition to interracial marriage?
I was listening to Ben Shapiro the other day talking about this a little bit, and he was like, there was, I think it was yesterday, where he had a whole episode on "You will be made to celebrate," and it's like, yeah, look how fast it says. It's like, oh yeah, even Obergefell, they're writing about how people of good conscience might oppose same-sex marriage, and now basically, oh, those people are evil. It's interesting how fast things can change sometimes. And for that matter, I don't know how many people still oppose opposite race marriages, but I suppose there's some in some communities. And what about their viewpoints? The whole thing is interesting.
Yes, because in how the law applies, not in discussion with folks, because of course honorable people have different views on this issue. But I think when you look at what Justice Kennedy said there, the way to honor that requirement is, as this court has set forth in Fulton, in Masterpiece, of having a rigorous interrogation to make sure that there are neutral and generally applicable laws applied in fact that way, that don't single out religion. And then the very next sentence of what Justice Kennedy said in Obergefell talked about when it transformed that honest and decent disagreement transformed into enacted law and policy, the necessary consequence is to put the imprimatur of the state on that exclusion. And I think if this court were to say that the imprimatur of this court would allow a web designer to say no same-sex people allowed, or allow a school photographer to say no pictures of...
Do you think Justice Kennedy would have said that that it's honorable to discriminate on the basis of race?
No, I don't think so.
Let me just give you one more hypothetical. Suppose someone offers the service of writing customized wedding vows or customized speeches to be given at a wedding by people who have an idea what they would like to say about a family member or a good friend, but they just don't feel they're very good with words. They can't put it into words. And let's say this outfit is just starting up. They don't have a lot of clients. They're sitting they're sitting by the phone and their computer waiting for somebody to show up. So they will take anybody. All right. Can they be forced to write vows or speeches that espouse things they loathe?
No, they cannot be forced to write vows or speeches that espouse things they loathe, because that's not a protected characteristic. But they cannot, I assume in your example...
Is the prohibition or the limitation against compelled speech limited to things that are unconstitutional?
No, I think there are...
So why does it matter?
Well, because here... things they loathe is not a protected characteristic anywhere that I know.
You do understand by things he loathes, things they loathe, he's including protected characteristics. You do get that, right? Apparently not. Apparently he doesn't get that. Apparently he's unable to follow the bouncing ball. When Justice Alito said things he loathes, he's like, no, that's not a protected characteristic. Okay, follow the ball, shiny ball.
No, but on the constitutional...
Okay, it doesn't fall within... You say it doesn't fall within your statute, but maybe it's going to fall within the statute. It may fall within another statute.
Under any level of scrutiny here, you look at the state's compelling interest in determining the incidental burden on in our example, the vow writer's rights, and I don't know of any state that has sort of a compelled, has the same compelling interest as they do for protecting things that other people loathe as they do for sex, gender, religion, discrimination. So
he couldn't follow the ball, or he didn't want to follow the ball. Probably more to the point. But okay.
I think it would be a different analysis.
Justice Sotomayor?
This would be the first time in the court's history, correct, that it would say that a business open to the public, as this petitioner has said it is, that it's open, a commercial business open to the public, serving the public, that it could refuse to serve a customer based on race, sex, religion, or sexual orientation, correct?
Yes.
Okay. Justice Gorsuch?
Good morning, Mr. Olson.
Is it still morning?
Just barely. It must not feel like it standing where you are.
I'm here all day, Justice.
It's good to see you. We've had some discussion about whether websites are speech or whether they are a service off the shelf. And I, like a lot of my colleagues, don't profess to know much about this. But I do know that there are some stipulations that you made in paragraphs 81, 82, 83, which say that this is customized, personalized, an expressive activity in each and every circumstance. What do we do about that from your perspective? Don't we have to take that as given?
Yes, but it doesn't change the analysis, I think.
Why not? Because I do see a thing very different if I put a cake on display, it's been made, it is what it is, or a website that you can then go customize yourself, and another thing to commission an expressive activity, and to require somebody to create an expression. Those are two different things, analytically in our law. So help me out.
Well, I think along with the stipulations, we need to look at the specific relief that the company seeks.
But those are the stipulations.
No, they are the stipulations. Yeah. And the specific relief that the company seeks is the ability to turn away every single same-sex customer.
Well, they can ask for what they want. What they get might be another thing, Mr. Olson. But how we analyze the case depends upon those stipulations.
Of course it does.
Okay. Okay. And then separately, I was intrigued by your answer before my friends at the 10th Circuit about freelance writers and people like that, and the notion that Colorado could compel, for example, an individual to write a speech or a press release on behalf of, say, a religious entity with whom he or she disagrees. Does every press release writer, freelance writer, have to write a press release for the Church of Scientology, say, even though the beliefs of that institution may be inimical to the person?
Not at all, and I admit I don't have firmly in mind the exact contours of my answer a couple of years ago to the 10th Circuit.
Bring it.
I will tell you what Colorado law says, which is a freelance writer may or may not be a public accommodation.
Well, let's assume they are,
okay.
Under your definition, pretty broad, very different than the historical understanding of public accommodation, but we've gone over that.
So assuming away that hard part of the question, getting to what limitations, all that Colorado law requires is that if you choose to offer a service to someone, you need to offer that service to
I offer
someone
to
else.
write press releases for anyone. It's not a who, but it is a what. And the what is I won't write a press release that expresses religious views or that I disagree with.
Well, I think certainly a freelance writer who is a public accommodation could say, I don't write press releases that express religious views, full stop. I won't write that for anybody. Right? You can.
You bring it, Neil. You bring it. You show them the consequences of this, right? You show them the consequences of this. We'll make it even purer speech, if such a thing is possible. We'll make it even purer. How about the press writer? How about the custom vowel maker? How about even more speech, more creative, more speech, more creative, more asbestos, more asbestos?
No. I'm happy to do it generally speaking, but just not ones I disagree with. There are many I would agree with across a wide variety of religious faiths. But I'm not going to do it for some with whom I disagree.
Well, even in that circumstance, what Colorado looks to is the service you actually provide, and you choose the service so long as you could say.
So the answer is yes, Colorado would compel that person.
No, the answer is no.
Okay, why?
Because Colorado could say, you as a speechwriter could say, I write, the religious speeches that I write touch on a few traditions that I have knowledge of, and I don't write speeches that touch on other knowledges.
Well, no, it's not. You're changing my hypothetical, Mr. Wilson.
Yeah, see, this is why if I were the other advocate, I would just said yes. Right? I would have accepted the extreme ends of my premise because I can win on the extreme ends of my premise. It's like, yes, this allows whatever we're saying speech is, it allows the people to be assholes. That's basically Justice Jackson's question at its core. I mean, at least in my interpretation of her question to the other advocate. It's like, hey, in the pure speech case, does this allow people to be assholes? Can the person not take the photograph of the black children? The answer is yes. And she's like, I'm aghast, I suppose. But I'm like, okay, well, that's just the answer. But here, this advocate can't do that. He can't accept the extreme version of his answer. Because we're going to compel the website designer. Oh, really? Are we now? Well, what if it's Wedding Vows Are Us? What if it's Speech Writers Inc.? What if it's Freelance Reporters LLC? And then yeah.
That I disagree with, that I find offensive to my religious beliefs. That's the hypothetical.
So long as you would sell that to everyone, not based on their religion, but you can define the contours of the product. You can choose the contours of the product that you sell. But
I call it speech, but you can call it a product if you want.
Nice. Bring it.
We'll call it speech.
Based.
You can choose the content of what you sell. You just can't
what you say.
Who you sell to.
Okay.
Right? And so you could say, I'm going to focus on these things, but I need to sell that to everyone, even if the person who wants to buy it is a member of a religious faith that I disagree with. That's fine.
I will write a press release for many faiths and many belief systems but they have to be consistent with mine, and I won't do it if it offends my religious faith. Good to go.
So long as you sell that to everybody.
Yes.
How that doesn't completely undermine his position is beyond me. But maybe Neil is just thrashing him to death, and he doesn't know the difference anymore.
Okay. All right. What's different about this case? Because, I'll just finish the question. I'm already ready to answer it. But we have an individual who says she will sell and does sell to everyone, all manner of websites. But she won't sell a website that requires her to express a view about marriage that she finds offensive to her religious beliefs. What's the difference between the two cases? I'm struggling to understand.
It's a pretty good question, Neil. It's a pretty good question. What is the difference between the two cases? Okay.
The difference is, and again, looking at the specific relief the company seeks.
Put aside the specific relief the company seeks, because it's up to courts to fashion relief.
Oh,
so that's not going to persuade me. Work on something that might.
Wow. I like that directness. Very much. It's like, well, it's because of their requested relief. Well, it's up to the courts to determine relief. Which, is true pretty much in every case. All the cases, right? It's always up to the courts to determine relief. Judges determine sentencing in criminal cases. Judges determine, the relief, and you can ask for anything. And the other party can ask for sometimes. And sometimes the courts give you a third thing altogether. Right? And so he just says, that's not going to persuade me. Work on something that might persuade me. Fire. Just crush him. Crush him before you. See your enemies driven before you. Hear the lamentations of the women's dial. Right? He's like, dude, look. Oh, it's because of the relief. Wrong answer. Try again. Lol.
The difference is that distinction, the company has chosen to say they want to provide wedding websites generally, and they will not provide
all manner of websites. This individual will provide all manner of websites, just not one that requires her to write something, words on a page, customizable, all the stuff you stipulated to, that celebrate a particular thing that she finds offends her religious beliefs. I'm looking for the distinction between the two cases. One you say is okay, the other one not okay.
Because the company, unlike our first example of the speechwriter, the company here says, in no uncertain terms, will they ever sell a company, a product or a service to a same-sex couple.
No, Wrong. That's not what they said. That is not what they said. They do, in fact, have same-sex. They have LGBT clients. They have same-sex clients. They will sell them products. So it is not, in fact, the case. The company has said we will never sell any product to a gay couple. They didn't say that. They said we won't create a wedding site for you. So 2 strikes. Let's give it another go. Spin that wheel. And no whammies. Stop.
What I say is we will not sell to anyone, a message that I disagree with as a matter of religious faith, just as a speechwriter says, or the press release writer, the freelance writer says, I will not sell to anyone a speech that offends my religious beliefs.
But here they are defining their service by excluding someone based on
That's their religious belief.
Well, in Colorado,
you can't change their religious belief, right?
No, but
and you protect.
I like that exchange. That's their religious belief. Well, in Colorado, implying that in Colorado it's not, and then say you can't change your religious belief. No. Well,
protect religious beliefs under the statute, right? That is one of the protected characteristics in theory
and in practice. If it wasn't in practice, we have heard about it over the past several years, and my friend has pointed to no example where this has been applied.
Mr. Phillips did go through a re-education training program pursuant to Colorado law, did he not, Mr. Olson?
He went through a process that ensured he was familiar with.
It was a re-education program, right?
It was not a re-education program.
What do you call it?
It was a process to make sure he was familiar with Colorado law.
Someone might be excused for calling that a re-education
I strongly
program.
disagree, Justice Gorsuch.
Thank you, Mr. Olson.
Justice Kavanaugh?
I'm interested in picking up on those questions.
It might be a re-education.
What Colorado's position on the First Amendment could lead to, not what you would do based on your representation, but what your theory of the First Amendment could lead to, and thinking about the proper analogy to a website designer. So I've been thinking about a publishing house that says we're not going to publish, we support pro-choice positions, we're not going to publish books that support pro-life position, or that we support same-sex marriage, and we're not going to publish books that take a different position on same-sex marriage. Does the publishing house have a First Amendment ability to select the kinds of books that it will publish along the lines of my hypotheticals there?
Of course it does, and I think a publishing house is not a public accommodation for precisely the level of selectivity and choice that it goes into, just like the court recognized in Fulton.
Right, but if it were a public accommodation, it would still have a First Amendment right, correct?
Yes.
Sure about that?
Yes, because what all the public accommodation law says is you can't turn someone away because of who they are. And it would be different if your hypothetical was they will not publish gay authors. If they were a publishing house,
right?
They won't
That's the distinction right there. Yes. You put your finger on it, I think. So the website designer is different from the publishing house. How?
Because the website designer is refusing to publish gay authors, using the publishing house example. They are saying, I will not provide this service to someone because of who they are, period.
They say it's because of the message.
I understand, but they define the service in a way that excludes people based on who they are, and that violates Colorado law. And to the extent there's some incidental impact on their message, it's the kind of incidental impact that this court held in O'Brien is to be appropriate, where a law is focused on conduct and not the message itself.
And I thought the amicus brief of Professors Carpenter and Volokh was fairly interesting. They supported the same-sex position in Masterpiece, but that they say they're on the opposite side in this case, and they say that the reason is because this case involves speech. They say a website designer is unlike a baker, and that Hurley, therefore, is the key precedent here. And they say there is no serious question, their words, no serious question that this case involves compelled speech. Do you agree it involves compelled speech?
No.
Okay. even though they say there's no serious question that it does. You disagree with that?
We disagree with that.
Thank you.
Justice Barrett?
Okay. They disagree that there's no compelled speech in forcing them to create a website. That's a bold proposition. Okay. So requiring them to service the gay couple client by having the wedding website for them is not compelled speech. Okay. All right. I guess Amy Coney Barrett is going to follow up on my incredulity, it looks like.
How can you disagree with that in light of the stipulations that Justice Gorsuch reviewed with you? Because if it's speech, you know, as the stipulations Justice Gorsuch did, and she has to say it, why isn't it compelled speech?
Pretty good question, Amy.
Because on the stipulations and where we are here, the company would refuse to provide the same identical speech to a customer solely because of who they are. And if the company is going to provide speech, already said they're going to do it, the website, I think it was the colloquy with Your Honor, Justice Barrett, where someone comes in and says, I want the exact same website as you gave to my friends, and the company says, no, I will not provide that to you, and the only reason is because of who you are, that's not compelled speech. Certainly there are some circumstances where there may be more of this, you know, tell the story, et cetera, but the company can choose to determine the services that it wants. Here it is chosen to say that I will not provide the exact same website for one couple that I would for another solely based on the identity of the couple.
Okay, I want to give you a hypothetical that doesn't rely on disagreement, philosophical or otherwise, with speech, but just a desire to promote a different kind of speech. So let's say a newspaper is running, as many newspapers do, runs marriage announcements. And so, you know, the New York Times says that such announcements, which it picks, have to satisfy its normal editorial standards. Let's just say that the newspaper for Gay Pride Month decides that it's going to run to promote and recognize same-sex marriage, only same-sex marriage announcements. Turns away heterosexual announcements, not because it disparages or disagrees with opposite-sex unions, but because it's trying to promote something else. Can it do that? That's a protected characteristic under the law.
Well, that's a hard hypothetical because normally the marriage announcements are considered to be a public accommodation, but your hypothetical introduces a layer of editorial discretion.
Well, you can't run every marriage announcement that comes. There would be too many. So you're necessarily going to pick and choose, just like every business is going to have to pick and choose based on resources.
Well, and I think, but in that circumstances, if the sole basis for picking and choosing is a protected characteristic, the New York Times couldn't say that we're going to have this month, we're just going to run opposite-sex weddings. Next month, we're just going to run white people weddings. Next month, we're just going to run.
So for Gay Pride Month, a newspaper can't choose to try to celebrate that and communicate a message by running only gay marriage announcements?
Well, again, I think the answer is no, but that's an unusual case because a newspaper obviously typically has great discretion.
That's an interesting one, isn't it? The New York Times, apparently, according to him, cannot. The New York Times, apparently, according to him, cannot decide for Gay Pride Month to only run gay wedding announcements. Okay. I mean, I will appreciate that he's willing to say that, because he is accepting the consequences of his position, which he was having problems with earlier. And I think as an attorney, this is one of the things you got to do as an attorney. You got to really think things through. And you got to really think through the entire chain of logic, right? At least in my mind. Because I tend to think in the logical, I tend to think, although not exclusively, but I tend to think in process rather than result. So I tend to look to process rather than outcome. And I tend to think in logical chains. And I tend to think through logical reasoning. And it's like, if this is true, what else is true? Right? And I think, to my mind, and that's how I think about law generally, and it works for me, I think all law can be thought of this way. I think all law can be thought of as one massive if this, then that exercise. And then, all of law is trying to refine the if, then that, right? It's all trying to refine the tests. But to me, there is a very logic flow. Not absolutely, because, it's pretty hard to comprise any human endeavor perfectly, but particularly to the extent that law extends further back, to the more black letter law and the more ancient law, the stuff that's more baked in, the original torts and stuff like that, where that law is based on hundreds, if not thousands of years of stuff, right? There's some stuff that's more well baked in and stuff where there's a thought through logic of it. And you can follow it in a logic tree. And I think one of the things as an attorney has to do is, especially as they're an advocate, when you're thinking about, not just the case in front of you, when you're at the U.S. Supreme Court, because if you're thinking just about the case in front of you, you're probably having a bad time, right? You got to think about the cases beyond that, because it's very rare the U.S. Supreme Court only answers the case that's in front of them. The U.S. Supreme Court doesn't really do that. The U.S. Supreme Court, in particular, thinks about things beyond that. So if you're on an appellate level, and particularly at the U.S. Supreme Court case, you got to think beyond the confines of your own case. You're a lawyer in your case. You got to defend your client. But if you're not thinking about the set of cases, because then you're just not doing your job. You got to think about the set of cases, and you got to think about, okay, if this is true, what else is true? And so I appreciate when an advocate has done all their diligence and thought everything through and tried to do all their thinking exercise and be like, you know what? This is just the logical consequence of my position. And this is the correct logical position. I have thought it through from every possible angle, particularly at the U.S. Supreme Court. You get lots of help. Typically, you do moots. You do fake hearings. You do moots. You get people. You have fake justices. You do fake hearings. You think it through. You try to attack it from every possible angle. You're like, you know what? This is my position, and that position can be nuanced. Right? That position can be nuanced. But you've thought it through, and whatever the position is, you just take it to the extreme in every nuance that you have, right? So you defend every point of your nuance, and more nuances in some sense makes it harder because there's more points of attack because you've raised more issues. Like if I'm going to have a nuanced argument and I've got 10 vulnerabilities because there's 10 things I'm trying to set up in this argument, then it makes it a little bit harder. But that's sort of the ground I play in. But I do like that he's accepting the consequence of his argument, at least at this point. He's like, yeah, the New York Times can't do that. The New York Times is a place of public accommodation. They write wedding announcements. They can't discriminate on the basis of sexual orientation. They cannot, as for Gay Pride Month, have only the Gay Pride wedding announcements. Now, the problem, of course, is when he gives that answer, you're like, dude, really? Because First Amendment principles. The New York Times doesn't have freedom of speech now, right? Whereas if the other advocate ran her position to the end of the page, you're just like, well, freedom of speech means you get to be an asshole, which is the right answer. It's a defensible position. But I do appreciate that he's trying to defend the extreme outcome of his own position. It's like he's chosen this battleground. This is the position I'm going to defend, damn it. And I'm going to defend it no matter even if it's the New York Times and Gay Pride Month. I respect that.
Might be an unusual case, but the problem and what a lot of the hypotheticals are getting at is however we decide this case obviously applies to others. And what if we say it's not the New York Times, but what if we say that it's a gay rights group that wants to publish gay rights announcements online all year round, not just for Gay Pride Month, because it wants to celebrate love in that community?
Uh-oh, danger, Will Robinson, danger. Okay, what if it's not the New York Times? What if it's Out Magazine? Is Out Magazine still a thing? Can they do that?
And so it publishes only same-sex marriage announcements and turns away opposite sex. Can the gay rights organization do that?
Well, I think that's very unlikely to be a public accommodation, so the answer is likely yes.
Well, they're paid. Why? I mean, they're paid. I mean, they craft these and it's a business, it's a commercial enterprise, but they craft these announcements for the gay community.
I guess who crafts the announcement?
It's a it's a gay rights enterprise. It's a group run by, people who are interested in promoting gay rights, and it's a forum to celebrate gay marriage. They charge, you make money, and you run marriage announcements that have our story, etc. But it's done specifically to celebrate love in that community. Can they turn away opposite sex marriage announcements?
In this unusual hypothetical, assuming they're public accommodation, they cannot turn away announcements based on a protected characteristic. So
Again, I appreciate that he answered the question. That is the correct answer from his framework. It is the inevitable answer from his framework, which goes to show part of the problem. But he's thought it through, man, and this is the position I'm going to take. It's like, yep, New York Times can't do it. Out Magazine can't do it. They can't do that either. That's fine. Yep, great.
they couldn't turn away opposite sex announcements or interracial marriages. I think if they're a public accommodation, but I think
so they can be compelled to. It's not that they have anything against opposite sex unions, but they can be compelled to give their web space to those announcements, even though it's not consistent with the message of their organization.
Again, assuming they were a public accommodation and opening themselves to the public,
assuming they're
yes,
public accommodation.
they can do that. But I think what makes the hypothetical difficult is that assumption.
Yeah, I mean, it's the only way for him to be logically consistent. Okay, I mean, it's why it's all burning to the ground around you, because when you try to apply a logical consistency, it all burns to the ground. But yeah, I mean, okay, he's going to defend himself standing in the fire, saying this is fine. Okay.
Likely does not apply to most organizations like that.
But it seems like you can't get out of everything by defining public accommodation narrowly or broadly, depending on it. I mean, you agree that in Hurley the parade was a public accommodation, as we held? Because Hurley is your hardest case, right?
It's a difficult case, but we are different than Hurley, and I'm happy to talk about why. But the public accommodation law was applied to the parade in Hurley, and the court said that was because of the peculiar circumstances there, it was inappropriate. But importantly, in Hurley, everyone could march in the parade. The only issue was who could carry the banner in the parade, and in this case, people can't march in the parade. The company is turning away people for their products based solely on who they are, and that's the big difference from here in Hurley.
Thank you.
Justice Jackson?
Yes. So I just wanted to say how perplexed I was about the questions that seem to distinguish this kind of sexual orientation refusal to provide services from the race discrimination.
I share her perplexal. This is why I wouldn't run away from the consequences of it. The First Amendment allows you to discriminate on the basis of race. Because the First Amendment is purely private action, right? Person's action. A person can discriminate on the basis of race. The First Amendment allows you to discriminate on the basis of race. Yeah. So this is why I wouldn't run away from it, because you can't make it work, I don't think, otherwise.
And there were some questions raised about, religion being the basis. But I guess, and you might be able to help me with this and you might not, but I was fairly certain that historically opposition to interracial marriages and to integration in many instances was on religious grounds. So I don't know that we can say that just because we have a religious objection to same-sex marriage in this situation, that wouldn't necessarily implicate religious objections to other kinds of situations. Am I right about that?
Absolutely correct about that. I mean, Bob Jones University is a good example of that case where there was a religious basis.
So whatever we decide here, as Justice Barrett suggested, could have implications for other kinds of categorizations in First Amendment, strongly religious held First Amendment invocations of rights.
Yeah, that is how the Supreme Court works. Yes, Justice Jackson, what the Supreme Court says here would have ripple-on effects beyond its own domain. Yes, that's true. Okay.
Absolutely, and I think the reason my friend was having such difficulty giving clear answers to some of these hard questions was because there is no way to cabin this to, under the free speech clause exemption they seek, just to weddings or sexual orientation.
All right, so
I agree there's no way to cabin it. That's why I wouldn't even bother to try. And just be like, well, the First Amendment says that. That's what the First Amendment says. The First Amendment trumps. The First Amendment trumps the Civil Rights Act. The First Amendment trumps Title VI, Title VII, Title IX. The First Amendment trumps non-discrimination statute. The First Amendment trumps. It trumps everything. That's kind of in the nature of amendments to the Constitution. They have a tendency of usurping everything. Yeah.
Can I just direct your attention back to Justice Kagan's question, because I think she made good points about the God bless this union hypothetical. And I guess I was thinking, isn't part of the problem trying to figure out whose statement of opinion it is when you have a public accommodation, when you have an artist for hire, right? Ordinarily, you would have an artist who, even though they're making custom things, they're making custom things based on their own views and opinions, and this is my art. But when you have an artist for hire and people come to them and say, here's what I'd like you to make, there's a question about whether what they make is their statement or the customer's statement. So if it was clear that it was not their statement, let's say the gay couple comes and they say, we want God bless this union on our website, and the web designer says that's fine, but you understand under our name at the bottom, we say on every website, we believe that marriage is only between one man and one woman, and we're going to put that on your website. Justice Alito says maybe that person will walk away, and maybe they will. But the point is, if they do that in every situation, and it's clear that it's not their statement, then do we solve the difficult Justice Kagan problem of like who's making an expression here?
I think we make progress towards solving it. And I think back to the stipulations, I think it's notable that the stipulations here do not address that question that you raised, Justice Jackson. What the company says is, well, every website has designed by 303 Creative at the bottom. That's paragraph 83 of the stipulations. And then they say, and if a viewer of a wedding website goes to 303 Creative, then they will understand our philosophy, our own website, then they will understand our philosophy and understand that there's some implicit, recognition or endorsement, whatever, of the wedding. But on the stipulated facts here, the question you pose is totally wide open. There's no evidence in the record whatsoever and no websites in the record to look at to see whether anyone would attribute the speech about the couple on the wedding website to the designer as opposed to the couple.
Should we have that as part of our standard in the holding? Like, let's say we don't want to go as far as you're suggesting, perhaps, with the holding in this case. Could it be that we would say, the First Amendment protects the web designer's abilities to, not have this kind of a same-sex wedding website only if it would be clear from a neutral observer or from the audience that having that website is their own expression?
So two things to say on that, Your Honor. First is, I think both Spence and Hurley itself talked about the importance of how an onlooker would look at the message and who the onlooker would attribute the message to. So I think certainly could build on that. And again, here there's no evidence whatsoever that anyone would look at a wedding website designed by 303 Creative and say, oh, that is the speech and beliefs of the designer as opposed to the couple getting married.
Thank you.
Thank you, counsel.
Thank you.
Mr. Fletcher?
Thank you, Mr. Chief Justice, and may it please the Court.
Yeah, he has problems. He can't take his position through. I've said this before, and I said it. I'll say it again. I really do like the philosophy of Immanuel Kant, which goes a lot to my thinking and how I express things. Right? Immanuel Kant is all about the categorical imperative. Immanuel Kant says that there is no ethical there's no ethics except that which can be maximized without contradiction. And I don't necessarily know that he was right in his extreme, but I think he was more right than not. Right? He certainly took his own philosophy to his breaking point and followed it through to the breaking point. I'm not necessarily sure that he was right in the extreme, but then again, Immanuel Kant's smarter than me, so I'm not sure I'm in a position to critique him. Anyway, he says, like, there's no position that can't be maximized. There's nothing ethical except that which can be maximized without contradiction. And so he is following. So in the spirit of that, our advocate friends over here, especially this guy in the back half in particular, has done a fairly good job of taking the position and running it to the end of the page. And like, okay, it's the New York Times. Okay, it's Out Magazine. Okay, it's this. Okay, it's that. And he's like, yep. I'm just going to maximize it, and it's all okay, and it's not compelled speech, and everything is fine. Everything is awesome, right? And I think that's a good thing to do, especially, again, in particular, when you're at the U.S. Supreme Court, because you got to at least try to think about the consequences, because our system is a common law system, which means it's precedential, which means that every case that comes down is a brick in a wall. And where you put the brick down depends a lot, not only on the bricks that came before it, but on the bricks that will precede it. Because, like, where you put this brick may influence future bricks, right? So you got to think, you got to try to think it through and think through the consequences of it and be like, okay, can I maximize this? And, we can't necessarily see all ends, and sometimes it's not clean, and sometimes you got to kind of be like, and just kind of like, like you got to take some chances and stuff because you're like, right? So I don't know that I necessarily follow it to its utmost extreme, but you got to think. You got to think about what happens next. And he's trying to think about what happens next. It's just that the answers really, really suck. And for that matter, Jackson is thinking about what happens next, because she's thinking, well, if this, why not the race thing? To which I'm like, yes, correct. Right, that's where I would drive that answer, and that answer would not work for Jackson, but it's the correct answer legally, as far as I'm concerned. Because it's like, yeah, the freedom of speech includes the freedom to be a jerk. So, all right, let's listen to advocate number 3 here.
My friend Ms. Wagoner offered a 2-part test this morning for when a commercial business is entitled to an exemption from a generally applicable public accommodations law. She said, number 1, is their product speech? And number 2, does serving a particular customer change the message in the view of the business? As the questions today have already explored, that leads to extremely sweeping results. It means that any provider of expressive services is entitled to put up a sign saying we do not serve people with particular characteristics whenever they believe that serving those people would change their message. What I want to begin with today is to explain why that way of approaching the problem is also inconsistent with this Court's cases, most notably Rumsfeld versus Fair, which you mentioned, Mr. Chief Justice. That case was not just about access to the law school's rooms. The law schools had a separate claim that said we provide other services to recruiters in the form of emails, newsletters, other things of that nature, and this Court did not disagree. It said those things are clearly speech. And the law schools also said when we are required to provide those services to the military, it changes our message because it forces us to support a cause we deeply oppose. And this Court did not disagree. Instead, it said that compulsion of speech is permissible because it is incidental to a content-neutral regulation of conduct, and the law schools are required to speak only if and to the extent they would provide the same speech for others. I welcome the Court's questions.
I do think the Court in Rumsfeld was dealing with the sort of compulsion that is significantly different from the compulsion here. In what other case have we upheld compelling speech? In other words, not simply just restricting speech, but actually compelling an individual to engage in speech contrary to her beliefs?
So I think, Mr. Chief Justice, Rumsfeld really is one of those cases, and I want to emphasize that the law schools there really did have a very credible claim, I think, that they deeply opposed the military's policies. And
well, they opposed the military's policies, but all they really had to do was give them an empty room.
Mr. Chief Justice, that's not correct. At pages 60 to 62, the court acknowledges that there were things that the law schools were required to do, like sending emails, coordinating meetings, including announcements in their newsletters, that were clearly speech. The court below had held that
advising people that the military recruiters were available in a particular room, right?
And including their announcements, distributing the announcements on behalf of the military, including the military's announcements in the law school's own newsletter. The court below held, and the law school
of the fact that they would be recruiting on campus pursuant to the Solomon Amendment. Do you think that's the same as the speech that's compelled here, which is directly opposite to the beliefs that the Ms. Smith is seeking to convey?
So I think it depends very much about what type of speech we're talking about here. I don't know that it is different in a constitutional sense from the sort of speech that was described in what Justice Kagan, I think, called the basic website, where we're talking about a website that presents in an attractive way the details of the couple's wedding. I think it might be a very different case if she were compelled, if Colorado ever applied its law to compel her to create messages or express religious views about marriage or to do some of the opinion-based statements that Justice Kagan described. But I think that case might well come out differently.
In other words, you would say that here's where the military recruiters are going to be, with those recruiters, of course, using a discriminatory policy that the law schools deeply objected to. Here's where the military recruiters are going to be is very similar to here's where the wedding is going to take place, which is what standard websites do.
Exactly. And in saying that, I don't want to at all minimize Ms. Smith's sincere religious objection to saying that for a wedding that she opposes. I'm just making the point that the law schools also had sincere moral objections to making those statements to facilitate recruiting that they found deeply objectionable.
What if the law schools also had to make available their CDO to sit down with the military and help them craft, a statement that would be attributable to the military? This is why a career with the military, this is what it would be, this is why it's attractive, and then post it. Would that change Rumsfeld?
So there was actually evidence that those sorts of services were offered that the law schools were pressing that are referenced in the Third Circuit's opinion but not specifically referenced in this court's cases. I think what that starts to get into is how do you draw the line between are you providing, is it really the same speech that you would provide for someone else, and are you being required to do something that goes beyond that to express the sort of opinion-related statements that Justice Kagan.
What if they do it for everyone? The Career Development Office will do that for, law firms. This is the job of an associate, and here's why it would appealing, what you'd be getting out of it. If they do that, then they would have had to do that for the military, or would that make that case more like Hurley?
So I guess here's the way I'd answer the question is the way that Hurley did. We read Hurley to ask, is the compulsion, is the burden on speech, is it truly incidental to the content-neutral regulation of conduct? And what Hurley started with on pages 572 to 573 is being emphatic in saying this parade is not excluding people because they are gay and lesbian, it is excluding them solely because of the message that they want to send. And so the court said applying the public accommodations law to them is not incidental. It's not serving the content-neutral regulation of conduct because they're not discriminating on the basis of status. Instead, the law in Hurley, the court said, was equivalent to a law saying that the parade had to include any message that any protected group wanted to offer. That is not an incidental burden on speech. That is a direct burden on speech. And the reason why we view this case as being like Fair and not like Hurley is because Colorado is not asking Ms. Smith to say messages or to speak messages that she would not speak for anybody. The only thing that it is saying is you can't discriminate based on status, and you can't define your services based on protected status, so that you can't say the message that I object to, that I won't speak for anybody, is a message that is tied to the customer's status.
Well, I mean, that's a really difficult proposition because, again, the problem is to some degree that his argument is equating and preventing any disequating. That's probably not the right word, but his argument is equating speech and status. And he's saying the problem is you can't discriminate based on status. Okay. You can't define your services based on protected status. Okay. So you can't say the message I object to is that I won't speak for anyone is a message that's tied to status. This is a problem. if the message is tied to status, if the message cannot be severed from status, then status is itself now speech. That is a necessary consequence of the argument. If the message is tied to status, it's inseverable, then status is itself the speech. Status is itself the message. Which, if that's true, then we're just back to freedom of speech. So if it's true that it's inseverable, so this is where his argument is breaking down for me. This is where his argument is breaking down. He says it's inseverable. Therefore, status wins. Because they're inseparable, status wins. I think the correct argument is because they're inseparable, speech wins. Right? If you're saying they're inseparable, what wins? You can't have you have two value propositions now. Right? This is like you have two masters. Right? This is what you have. You have two masters. So you have speech, the message, and status. Speech / message on the one hand, status on the other hand. So you have two masters. You said, okay, there is a point now we cannot sever them. So now you have these twin masters that cannot be severed. They are inexorably tied to each other. So, okay, you can't serve two masters. So who wins? And he says, well, status wins. You can't discriminate on the basis of status. But that's wrong. It has to be wrong because discrimination on the basis of status is illegal because of statute. And statute has to give to the Constitution because the Constitution is the supreme law. So if it's a contest between speech and status, and it's a private actor, mind you, it's a private actor, not a governmental actor. If it were a governmental actor, we'd be asking different questions. But it's a private actor. So it's a private actor. And you say, okay, status is tied to message. Status is tied to speech. What wins? And the answer has to be speech because speech is reflected in the First Amendment. Status is reflected in the Civil Rights Act, non-discrimination statutes. And because the Constitution is the supreme law of the land, the First Amendment must trump. So that is where his argument ultimately breaks down. Now, I will emphasize again, for like the fifth or sixth time in this video, that this applies, of course, to the extent speech applies. And then we're just back, and now in the proper line of inquiry is now, is this incidental to speech, like Hurley, or is this core speech? So if it's Oli's Barbecue, if it's Heart of Atlanta Motel, to the extent any speech does exist, which probably not so much. I mean, what speech message is really being conveyed and who eats your barbecue? Not much. And if there is any, it's so incidental that it's not the issue, right? But this is pure speech. The New York Times is pure speech. This website is pure speech. Out Magazine is pure speech. So when it's speech, 303 Creative wins. Heart of Atlanta Motel loses. 303 Speech Creative wins. And that is the logically consistent position. In my view. And when it came to the law schools, I'd have to go back and reread that case law on that issue. But again, it might be so incidental that maybe that's not the problem. Maybe it's okay. Like, it's so incidental with the court because we have to give you a room and like, yeah, we have to mention you in like an email, like they're here. But it's so incidental, maybe it's different. Although we could go back and question even the recruitment case. It's been a while since I've read it. But yeah.
Well, I don't know how many of my colleagues have looked at the actual website. I don't even see celebration of marriage in any of the examples. Exhibit A, page 51, says, save the date. Lily and Luke, November 20th. You're invited. And it says Lily and Luke and the date and place, the town. The Exhibit 52 is counting down the days. Doesn't even say what it's counting down for, except our special day, which everybody has to assume is the couple's. 53 is an RSVP with pictures. 54 is our blog. Bring your dancing shoes. 55 is their date. It all began 7 years ago. Lily's version and Luke's version. It's clearly not 303's version. We love each other and coffee. I don't even know what CO, Colorado. Jesus, dogs, and diving. We love each other is the couple who loves Jesus. I assume your adversary won't say Jesus doesn't love them back, but it doesn't say that. The 57 is the ceremony. 58 is the reception, location, spirits, dinner menu, and dancing. 59 is location. I don't see anywhere I'm celebrating the marriage, or God loves anyone, or anything to do with anything like that. So have you reviewed this website?
I have, Justice Sotomayor.
Do you believe that there's any page that says celebrate the marriage?
Honestly, as I stand here today, I can't remember whether there is or not. I don't think it would make a difference if there were, and I think what the examples that you just read highlight is that there is a lot of websites or content on websites that is properly within this case because it is consistent with the stipulations, Justice Gorsuch, and with the scope of relief that they're asking for and with the type of services that Ms. Wagner has described this morning.
What they're asking for is a status-based exemption to accommodate.
That's exactly right.
Well, on that,
I thought
not a
the problem isn't that it's a status-based accommodation. The problem from your own framing or Justice Jackson's framing or whoever's framing it was, I don't even remember at this point. The problem is the status is tied to speech. That's the problem, right? That's the problem. So they're discriminating on the speech, but the speech is tied to status. And so okay, well, if that's true, if the speech is tied to status, to discriminate on speech is to discriminate on status. To discriminate on status is to discriminate on speech. That's the nature of two things being tied, right? To influence the one is to influence the other. That's what it means for two things to be tied together, right? So to discriminate on speech, if they're tied, is to discriminate on status. To discriminate on status, if they're tied, is to discriminate on speech. So what wins? The First Amendment. But that's just like a natural, inexorable consequence of this whole thing. And you don't have to blow up the entire Civil Rights Act to do this. Incidentally, by the way, this is not unprecedented either. Like the Civil Rights Act also prohibits discrimination on the basis of race in hiring. But it's long been understood a First Amendment exception, although the statute doesn't say it, but it's long been understood to be a First Amendment exception if you're, for example, putting on a theatrical work. You're Hamilton, right? You need to put on a theatrical work. So you want to have cast a particular way. So can you discriminate on the basis of race in hiring for roles for your play or movie? The statute doesn't say you can, but of course you can. Because who is portraying it might send a message. And depending on what message you're saying, that may be important to you as the artist. So this concept is already understood in law, to my mind. So it's just a natural extension of what's already understood in law.
Speech-based exception.
I thought at pages 188A and 189A, the stipulation below said that the additions to the web page stated, and then it lists the firm belief in God that they, Ms. Smith, subscribed to. Do you understand that to be part of the stipulations or not?
I do, Mr. Chief Justice, but that's referring to her website, her business's own website, not the websites that she would create for clients and not the websites that would be subject to the public accommodations law.
We also,
I'm sorry, go
no,
ahead.
No, please, Chief.
I was just going to say also on page 188A is the stipulation that her religious beliefs will be unmistakable to the public after viewing the addition to the web page.
Yes, once again, that's describing her website, not the websites that she would create for clients or the Colorado law might require her to provide on a non-discriminatory basis.
And counsel, we also have stipulations from Colorado that the plaintiff is willing to work with all people, regardless of classifications such as race, creed, sexual orientation, and gender, right?
In some respects, yes, but
no, that is the stipulation. I just read it. You disagree with that? It's the stipulated fact in this case?
That is stipulated, but it's also clear that she will not provide any wedding website for a same-sex couple.
For a same-sex wedding, and she wouldn't provide it to a heterosexual couple either, right?
But that's still discrimination within the meaning of...
Just as she wouldn't sell a website that celebrates a heterosexual union that she disagreed with to anyone, regardless of their sexual orientation, right?
That may be right, Justice Gorsuch, but I think Masterpiece couldn't have been clearer in saying that declining to sell goods or services, even expressive goods and services, for a same-sex wedding is a form of status-based discrimination properly within the scope of public accommodation.
You think Masterpiece said all that? Masterpiece couldn't have been clearer in saying that declining to sell goods or services, even expressive goods and services, for a same-sex woman is a form of status-based discrimination properly within scope of public accommodation law? What? How are you getting all that from Masterpiece? What? How on God's earth are you getting that from Masterpiece? Masterpiece was kicked from the Supreme Court because of religious animus reasons. They said that the Colorado Human Rights Commission, Kafka squad, whatever thing, was openly religiously animously hostile, which was manifestly clear from the record, incidentally. And so the problem was that they were manifestly discriminating on the basis of religion in evaluating the case. Masterpiece didn't deal with the merits. Masterpiece didn't address the merits. I mean, it kind of maybe a little bit somewhat had some tea leaves floating in the wind, but those tea leaves floating in the wind, first of all, were subtle. Second of all, were dicta because they weren't relevant to the case because the Supreme Court wasn't deciding it on the merits. They kicked it back for procedural reasons. And he says, okay, Masterpiece couldn't have been clear in saying that declining to sell goods or services, even expressive goods and services, for same-sex wedding is a form of status-based discrimination properly within the scope of public accommodation. What Masterpiece case were you reading?
On that, I just want to make sure I understand. Do we agree as well that this work that the plaintiff performs is expressive in nature?
We do.
Okay, thank you.
And if it's expressive, what about my photograph hypothetical?
So I didn't belabor this at the beginning, Justice Jackson, but your photograph hypothetical is exactly the sort of implication of the arguments that petitioners are advancing that are of concern to the United States. We really do think it's very difficult, if you accept her principle, is it speech and does the speaker believe the message has changed, to say that someone who is doing that would not be entitled under her theory to an exemption from the public accommodations laws. And we think that's a very sweeping accommodation that's inconsistent with the court's admonition in Masterpiece Cake Shop that any sorts of carve-outs in these areas have to be carefully cabined to avoid undermining the government's compelling interest in ensuring that all Americans have equal.
This guy got a lot more from Masterpiece Cake Shop than I did. He got a lot more from Masterpiece Cake than I did. Do we have to go reread Masterpiece Cake Shop? He's getting a lot more from Masterpiece Cake Shop than I did.
access to the public market.
And so just to be clear, right, it's the same photograph for both customers, that this expression in my example is classic scenes with Santa.
But it's not the same photograph now, is it? It's two different photographs. Is he talking about Masterpiece Theater? No, he says Masterpiece Cake Shop. Okay.
It's a Wonderful Life, 1940s. And we want, the artist, the photographer wants Santa with the kinds of depictions that are in that movie. And he wants to sell that to everybody, but what that means is only some people can be depicted in that picture. Is that, I'm just trying to make it, because we've heard a lot of questions about, well, isn't she customizing it? I mean, he's customizing each photo. But what he's saying is, I won't do the customization for these folks who want depictions with Santa because that is inconsistent with my beliefs about how that scene should be depicted, and I'm an artist, and you'd be forcing me to put out into the world pictures of Santa with children that I think are inconsistent with my view of how Santa should be depicted.
We agree, Justice Jackson. We think if you accept petitioner's theory, the upshot is that photographer or a photographer who says, I won't take corporate headshots for women because I don't want to send the message that women should be leaders in the workplace, can deny service to a class of people.
Mr. Fletcher.
Yes, that would be a logical consequence of that. I would imagine the corporation might not hire the person who's like, I'm only going to take headshots of the men, though. I would imagine the guy who specializes in taking headshots of corporate persons is going to have a difficult time finding corporations to hire him when he's like, but I'm not taking any headshots of the women, though, because I don't think women should be allowed to be in the workplace. I'm not sure what parade of horribles this is. I'm not sure that corporations are going to have a harder time than they do now in finding people to take their corporate headshots. Does anyone know what they're talking about? Because I'm not sure.
Sure. What if you have a gay couple who runs a web design business in a college town? And, a big part of their business is developing websites for student organizations, the environmental organization, like different rec club leagues, whatever. And then you have a Christian organization or Catholic organization that basically stands for and advocates traditional views of marriage. This is the raison d'etre for the club. They host debates, invite speakers, and they want the standard website that this couple provides in their business, which is, graphics that make it look appealing, kind of an About Us page that describes what they do and what their beliefs are. And let's say that this couple, like 303 Creative, has on the bottom of every page, designed by, Jack and Michael. Everything this club wants to say is an anathema to this couple. Do they have to, can you compel that speech? Do they have to publish it?
I don't think they do.
Why?
Because I don't think that's a refusal based on status.
Okay, this is my question. That's why I asked it. Because I think here there's a difference of opinion about whether turning down the same-sex couple simply for purposes of the marriage announcement is a turn down based on status or message. And it seems to me in my hypothetical that the status of the club is inextricably intertwined with the message they want to speak. So why is it different?
For a couple of reasons. I think, first of all,
this is fundamentally the problem. Inextricably twined. Like, they've said it a couple times already. And Amy Coney Barrett is just like, and I think it was Jackson who brought it up. It's like, it's inextricably twined. And she's like, yeah, it's inextricably twined, so speech has to win. And he's like, no, it doesn't. But it's inextricably twined. See, this is what happens when you follow things all the way through, like in a consistent way. So, yeah.
To start with the same-sex marriage context, this court has recognized that that's a circumstance where status and conduct are inextricably intertwined. In Lawrence and Masterpiece, the court has said refusing to serve for same-sex marriages is discrimination against gays and lesbians because status and conduct is inextricably intertwined. The public accommodations laws and the anti-discrimination laws generally don't work that way in general. We don't think that the expression of particular views is inextricably intertwined with having a particular religion or being a Democrat or a Republican. In general, in public accommodations laws, we say when you discriminate against someone because they want you to print a website or serve an event or cater an event for something that you disagree with, we wouldn't say that that's a status-based refusal. And I think that's correct. I don't think...
So this is a carve-out.
In general, in public accommodations law, we say when you discriminate against someone because they want you to print a website or serve an event or cater an event for something you disagree with, we wouldn't say that's status-based. Well, that's probably true a lot of the time. It's not that speech and message is always inextricably tied with status. It's not that they're always the same thing or always tied. That's certainly true. So in general, I think I agree. In general, when you discriminate against someone, generally that isn't status. But in this example, it is status because it's inextricably tied. So, yeah, okay.
That's applicable just to the same-sex context.
I think it's a context. It's like the court's recognition in Bray that a tax on yarmulkes is a tax on Jews. There are certain rare contexts where status and conduct are inextricably intertwined. And
right. It might be relatively rare. I in the grand scheme, I think it is relatively rare. But we're there. We're there in this hypothetical. Or this reality because it's stipulated facts. We're not even in a hypothetical. We're in a real case. So there are rare contexts in which they're intertwined, and this is such an example. And then what wins is the question. He says there's certain rare contexts in which status and conduct are inexorably intertwined. And for that matter, speech and same-sex marriage. So, okay. I mean, that's, yeah.
I think the court has rightly recognized that same-sex marriage is one of them.
Thank you.
Justice Thomas? Justice Alito?
I want to make sure I understand some of the contours of your argument. So my first question is whether you believe that speech can be compelled so long as the person who is compelled to speak is not associated with the compelled speech.
That's not the line that we draw, Justice Alito. I think we've focused on, is it being compelled incidental to a content-neutral regulation of conduct, as in fair, or is it not?
Well, outside of that context, in general, does the prohibition or restriction of compelled speech apply only where there is no danger of attribution?
I don't think so, no. I would imagine applying in other contexts, too.
Okay. Do you agree with Mr. Olson that a website for marriages can tailor the website in a way that makes the website unacceptable to same-sex couples?
By saying, for instance, on every website, we believe that marriage is only between one man and one woman or something like that. Yes, we do.
You believe that's permissible?
We understand that to be permissible as a matter of Colorado law, and also we think that's consistent with the way the public accommodations law is usually.
Mr. Olson's answer to that was if a website, or part of the answer at least, was that if a website included something like that, that would cause the website to lose a significant amount of business because some opposite-sex couples wouldn't want that. But that's dependent on the views of the community about about same-sex marriages. What if it's in a community where 99% of the public agree with that view, that same-sex marriages are bad, and they're happy to have that associated with it?
So I don't think my answer changes, Justice Alito, because I think that imposing a requirement or prohibiting that inclusion on a website is directly targeting the expressive content
Isn't
of the
that
website.
kind of a silly distinction?
Justice Alito, respectfully, no, I don't think it is. I think it's one that's familiar both to public accommodations laws and to the First Amendment. So in the public accommodations context, as Mr. Olson said, you could have a store that can say, we sell products that are solely related to Judaism, and it's not likely to be appealing to Christians or Hindus, but no one thinks the store is violating the public accommodations laws unless it says no Christians or Hindus may enter, and then it is violating the public accommodations laws.
Is there any limit to how broadly a state can define a public accommodation? So, suppose the state defines it as any business, a business that provides services to a significant portion of the public. Would that mean it can't be regarded as a public accommodations anymore?
I don't know about that line specifically, Justice Alito. I will accept the premise of the question. I do think there are limits as to how far the state can go, at least when we're talking about what's a sufficiently substantial interest to justify or to pass scrutiny under the O'Brien test.
Well, I ask this because a lot of the arguments on your side seemed to view public accommodations that if it's a public accommodations law, it's generally okay. There's no problem with it. And that's why I want to know how far that can be expanded. So some selectivity would not necessarily take a business outside of the definition of public accommodations. The same arguments would apply.
Some selectivity wouldn't take them out, but I think the farther the state wanders from the sort of traditional core of commercial establishments that hold themselves out as serving the public, the weaker the state interest is.
What about the characteristics that form the basis for an impermissible denial of service? Any limit to those?
I think they're the same answer, so not in the sense that a state can define its public accommodations laws however it wants, but yes, when it starts to bump up against the First Amendment and you're applying the O'Brien standard, protection for some characteristics, things that go beyond the traditional things like race, sex, sexual orientation, religion, those at issue here, and get out into political affiliation or,
It can't define it as political affiliation. It can't decline it to include political affiliation.
I'm not saying it
ideology.
I'm not saying it can't define it that way. I'm just saying that the interests supported by such a prohibition would be weaker than the really core ones like those that we see at issue here.
Okay, so how much selectivity do you think is required?
So that's going to be, I think, in the first instance, as a state law matter or as a constitutional sort of backstop matter, I think it's hard to give a precise answer. I think the court's opinion in Fulton gives some guidance and says more selectivity, more individualized review is less likely to be a public accommodation. And in contrast, an entity that generally holds itself out as open to the public can't escape the public accommodations laws just by imposing a discriminatory limitation or some pretense of selectivity. And I know I can't give you a bright line, but I think this is a familiar problem in public accommodations.
Okay, I think my last question. Suppose 303 Creative says that there's so much demand for our services that we have to be selective in who we choose. Would this case come out differently then?
I don't think so, Justice Alito. I think that a business that is open to the public and serves the public but has more business than it can handle and so has to be selective is still a public accommodation.
That's the right answer. That's the right answer.
Sotomayor? Justice Kagan?
Mr. Fletcher, when I read your brief, I had the sense that you and General Olson, Colorado, parted ways on some matters. And I'll just, on my hypothetical, God blesses this union, I thought that you might find that more difficult than General Olson. And I'm wondering if I'm right about that, and if I am right, why, and what that says about your argument generally.
So let me give you the answer I give today. I'd start with just the same observation that General Olson gave you, which is that I think their free exercise clause issues might come into play. I'll put those to the side because this is a speech case, right? And I think what that pushes on is, can the person who's providing services credibly say, I'm not denying service just because of status. I'm denying service because there's some message that's not just tied to status that I'm not willing to speak for anybody. And to me,
gay marriages are wonderful, to take the religion out of it.
Right. So obviously, Ms. Smith can say, I will not make any wedding website for anyone that says gay marriages are wonderful. She can refuse on that ground. Colorado agrees. We agree. Right?
Right. I guess the God bless this union was supposed to be so that it would be she would be like perfectly fine with saying it for some couples and not fine with saying it for other couples.
Correct. Yes. And I guess it's a harder case. I think it's one of the reasons why this case is frustrating is because we don't have any concrete facts. I think my inclination on that case is that I think she has a strong argument to say, really, that is making me send a different message because of the context. It's not a literal test. It's not just are the words exactly the same, right? We acknowledge that context matters. And so in a case like that, I think she has a much stronger claim to say, if Colorado applied its law to make me say that, and I think it's far from clear that Colorado would, then it wouldn't be imposing the sort of incidental burden the court saw in Fair. Then it's imposing the sort of direct burden you saw in Hurley, and the analysis looks very different.
Yeah, so what you said is part of what frustrates me about this case because, I guess my view when I'm trying to think up hypotheticals for myself is a little bit, it depends. On the first set of hypotheticals I gave, I would come out one way. And on the second set of hypotheticals I gave, I hope I'm not giving too much away,
I'm trying to give her the benefit of the doubt. It sounds like she wants to basically have her cake and eat it too. I'm trying to be a little bit more charitable than that though. But it sounds like it's selective treatment. It's like, well, I keep coming up with these hypotheticals and I keep coming up with disparate answers. Now it could be because there's a principled reason. Or it could be that I just don't know yet. Or it could be that I just want my cake and eat it too, depending on what seems most convenient. So, I mean,
I think it's much tougher, and I might come out the other way. And it really depends on the facts and on what exactly Ms. Smith is being asked or compelled to do. And that matters. And we have a case without any of that in it. And what should I do with that?
So I think you should take the case as it comes to you. And as it comes to you, it's Ms. Smith saying, I want to post a sign saying I will not provide any websites for any same-sex marriages. That's PEDAP 7A.
Categorical rule.
Categorical rule based on status.
Categorical rules is what Kant likes, baby.
And at page 303 to 304 of the joint appendix, which General Olson referred to, that's the relief that she's seeking, how she's framed her claim. What she wants is an injunction that says you can't.
Justice Gorsuch says we don't want to do things based on relief because courts are in control of relief, so take out that part of your, whether he might be right, he might not be right, but would it matter if we took that out?
I don't think it would, because what I heard Ms. Wagner say this morning when she was asked about what her client wants to do is that the services she'd provide are not limited to the ones that are described in the stipulations. She would provide something that wasn't so customized as long as it was to an opposite-sex couple, but she wouldn't provide it to a same-sex couple. That is what she is asking the courts to validate. And I think the court can take that claim as she presents it and say on that level of generality, she is not entitled to pre-enforcement relief. But I think it can also do, because I recognize there are harder questions out there, it could and should do what it did in Holder versus Humanitarian Law Project and Doe versus Reed and say, in rejecting this facial challenge, pre-enforcement challenge, in part because we need more facts and we don't have them, we are not foreclosing the possibility that there's narrower relief in future cases with concrete facts.
Last question. You said to Justice Jackson that you didn't want to belabor the point, but her hypothetical is exactly the kind of hypothetical that you're concerned about. You must have done many moots of this case and thought of many hypotheticals. What are your two ones that you're like killers? If we rule for Ms. Wagner and her client, what happens? Give me two hypotheticals.
That's a lot of pressure on my mooters. My favorite one.
It's a strange way to ask about what are the consequences of your opponent's argument if they're taken to the wall. But okay, that's a strange way to ask that question.
Is this court's decision in Runyon versus McCrary, which was about a school that wanted to exclude children of particular races. And it said the reason we want to do this is because segregation is important to our beliefs, and that's what we want to teach. And this court said you are free to teach segregation in your school, but you can't act on that belief by excluding children of particular races. And I think there's a private school, obviously. And I think if petitioners are right, that case comes out differently as long as the school can come in and say, when we teach, we are expressing messages, and those messages change when we express express them to students of different races. I think that's very troubling. And I guess I take Justice Alito's point that I do not mean to equate those who have different views about marriage to racists, but the reason why I rely on those hypotheticals is because this Court's First Amendment jurisprudence does not distinguish between views we find odious and those we respect. The same principles apply in both cases. And if the principles lead to unacceptable places when we consider them in light of odious views, then I think we have to reject those principles even in a case where we sympathize with and respect the views.
Thank you.
Justice Gorsuch?
I think at the end of 2 hours, we are now in the afternoon, by the way.
Good afternoon.
There's actually radical agreement on how we should analyze this case legally. Tell me if I'm wrong.
I disagree, but go ahead.
You haven't even given me a chance. That what would be impermissible is discrimination on the basis of status, but what would be permissible is refusing service because of a disagreement about views.
So I guess the reason I disagreed at first is to say I think there is general agreement that that's about the right outcome.
That's about the right way to think about this case.
But great difference of opinion about how legally you get there, and that leads to difference of opinion about how you answer it.
You're just stealing my thunder, counsel. You think this is a status case. The other side thinks it's a viewpoint case. Is that fair, too?
I wouldn't say that. I acknowledge that this is a status and a message case.
Okay, it's both,
yes.
In your view. I'm sorry. Whereas they would say it's a message case.
Correct.
But to think about it, the status versus message I just want to make sure we all agree that that's the right way to think about this case.
Correct. And can I explain why we think that's the right way to think about the case? Because we think the first question is the burden that's being imposed on Ms. Smith incidental to a content-neutral regulation of conduct that says you can't turn people away because of status?
Boy, oh boy, if this is what qualifies as incidental, to a content-neutral regulation, which is the law, by the way, part of Atlanta Motel and Ollie's Barbecue and Hurley. But man, if this is what qualifies as incidental to speech, woof. I mean, I guess maybe if we squint at the fact pattern just right, maybe we can get there, but a little bit why? So I suppose maybe if we really wanted to, we could squint and we could say, okay, in this particular case, we'll get all highfalutin about it. In this particular case, with these particular facts, this is an incidental burden. But if we had a different case with different facts, then somehow not. But I think that's a tough road to hoe, because if it's not this, it's hard to imagine that we're really going to do it for the case that's beyond that, right? This case is, if not at the wall, it's approaching the wall. There's not a lot of daylight between this case and the wall. I suppose we could try to create some, but it's hard to imagine that we're going to be like, oh yeah, not here. But if the appropriate case comes, then we're totally going to do it. I mean, that's asking a lot. If this is incidental conduct on speech, okay, that's all right.
So to us, the first question is what she's doing status-based discrimination? Right. And if the answer is yes, then the burden is incidental, even if she thinks it affects the message.
I got that about an hour ago, but thank you.
I apologize.
Now, the other question I had is, in your view, this is status-based, but Justice Barrett's hypothetical of the inverse situation is message-based.
I wouldn't describe it as the inverse situation because I didn't understand the hypothetical to say that the campus print website design company was turning people away because of their status. I understood it to be turning them away because they wanted to say things that the company would not say.
That's one way of describing it, or one might describe it as turning away those with traditionalist views of marriage based on their religious beliefs. Conservative Christians, for example.
So I guess I just disagree with that, Justice Gorsuch. I think the way we answer any status-based discrimination question is we change the protected status, we hold everything else constant, and we ask, does the outcome change? And in Ms. Smith's case, you change the protected status, it's, Jack and Taylor, and you ask, will she make the website?
Except for that runs into all those stipulated facts in which the plaintiff has said repeatedly that she will serve everyone and she would deny everyone this kind of website.
But denying everyone,
regardless of status.
Right, but
I have a sneaking suspicion that this case will be more narrow than would please me. I hope I'm wrong, but I have a sneaking suspicion this case is going to be more confined to its parameters than I might ideally like.
It's race discrimination to say I won't serve interracial, I won't create websites for interracial marriage, and I won't sell them even to a white wedding planner. That's still race discrimination.
It can be status or it can be message, and we have to figure that out in this case, right?
But the way you would figure it out is
we've already figured that out because we said that the status and message was inexorably tied. So you don't have to figure out if it's status or message because it's both. And that's just a question of which wins. But that's just what I think.
As Colorado validly defined it as status-based discrimination, and I think the answer that the court gave at pages 1727 to 1729 of Masterpiece is yes.
Okay, got it. Thank you.
Justice Kavanaugh?
Just want to follow up there and ask about one thing in your brief. On page 32 of your brief, you deal with a few hypotheticals. The hypotheticals you dealt with were requiring Muslim filmmakers to promote Scientology, compelling lesbian artists to design church websites criticizing same-sex marriage, or, and the third one I really want to focus on, or forcing writers to write speeches that violate their most deeply held convictions. So those are the three hypotheticals you posit, responding to the other side. And then you say, those hypotheticals, unlike this case, involve direct burdens on speech because they contemplate speakers being forced to create and convey ideological messages they would not create for anyone. Mm-hmm. And I think the other side would say that's exactly this case, too, to take that third category. These are writers, in essence, being asked to write speeches that violate their most deeply held convictions. So I'm trying to figure out, given what you say there, how you would say this case does not involve the same thing as a writer being forced to write speeches that violate their most deeply held convictions.
Because in each of those hypotheticals, you can't posit a content-neutral law like a public accommodations law that would validly require the writer or the speaker or the filmmaker to do what the hypotheticals posited. It's because in those cases, as we say, it's a direct burden on speech. The regulation is compelling you to write something you deeply disagree with because of the message. It's not incidental to a content-neutral regulation of content.
Again, to try to say that this is incidental is that's a pretty tough road to hoe. That's a pretty tough road to hoe. So this is incidental to speech. You know, the writer, the speaker, the filmmaker is a direct burn, but this is incidental to a contract neutral regulation. You're slicing that. You're trying to. There's a lot. You're trying to slice that pretty thin, man. To be like. And that's a
conduct like the court confronted in Fair and like we believe it's confronted with here.
You don't think applying a public accommodations law to a speech writing business that offers to do speeches or PR releases for anyone, but they say, oh, we're not going to do this message. You don't think that's this? They would say that's this case, and you say it's not because...
I think they'd be wrong. So first of all, at a couple of levels, speechwriters aren't likely to be public accommodations. Set that aside. Suppose you had one that was one, right?
Until they are, after this case, if you prevail, I mean, that's what states could do.
But I've tried to give you, in response to Justice Alito, there is, I think, a constitutional backstop about, core public accommodations laws we think satisfy O'Brien's scrutiny. If a state wanders from that, not so much. But again, just to get to the nub of your hypothetical, we think if the speechwriter says, here's a speech that expresses views that I abhor and I won't write the speech, they wouldn't do that for anybody, regardless of status. Now, it may be that the status of the person who's asking them to write the speech is somehow correlated with the message in some way, but that's still not status-based discrimination in the way that the law regards discrimination against people who are entering into a same-sex marriage as status-based discrimination.
Okay, thank you.
Justice Barrett? Justice Jackson?
Can I just say that I'm sort of trying to think about what you've just said in your exchange with Justice Kavanaugh. It's late. By wondering whether or not it has something to do with the message being implicitly provided in a situation in which what's actually being stated is the same. So, what would you think of a holding that says that the First Amendment protects this designer's right to provide products that explicitly express her beliefs about marriage? So she absolutely has the right to say one man, one woman in every website, and she has the right to refuse to say gay marriage is great in any website. But what she's really asking for in this case, I think, is the right to say the same thing. Here's the wedding, it's at this place, et cetera, et cetera. But she's afraid that if she says it for gay people, that will be sort of like an implicit endorsement of their wedding. And so she wants to be able to protect against implicitly endorsing, right, in a way that we've never really recognized before in the same way, when it isn't really clear that that's her message, when an objective observer wouldn't know that she was really trying to do that. Am I right in trying to think about explicit versus implicit in this way?
I think that basically maps onto the test that we're trying to give you, which is to say if she's discriminating based on status, and that includes if she's defining the message or the product based on the status, defining the what by the who, that's not okay. But other than that, she has the freedom to define her own product. And I think I'd agree with you entirely that the court has never recognized that sort of implicit problem as being sufficient. And in fact, I would say in fair, the court squarely rejected it, where the law schools had a claim that was very, very similar in structure to say we don't want to implicitly support these policies we deeply, deeply oppose. No one doubted there was implicit support. No one doubted it was speech. But because it was incidental, the court upheld it.
Thank you.
Thank you, counsel. Rebuttal, Ms. Wagoner.
Mr. Chief Justice, the United States says that you can refuse to express messages unless those messages are about marriage and unless those views on marriage have to do with believing that marriage is between a man and a woman. That's a significant concession that the government has made. In terms of this issue of categorical denial, the only categorical denial that Ms. Smith seeks, or a categorical request she seeks, is to have message-based protection that the First Amendment already provides. It's based on the message, and in that way, this court decides every speech case based on the message. We can look at FAIR, we can look at Miami Herald, Tornillo, all of the court's cases on speech where compelled speech is applied. You will see the affect or alter the message test, including in Hurley. And in order to rule against Ms. Smith in this particular case, it does seem that the court would essentially have to overrule that Hurley framework. Second, Chief Justice Roberts raised the issue of FAIR and how FAIR applies, and the United States has suggested that somehow this case is closer to that. But in FAIR itself, FAIR was about a duty to give access to empty rooms. The logistical emails that were to send directions to how to go to those rooms was a duty that was required to facilitate legal conduct. This case is speech that's only incidental to speech. When you have a speech creator, you're in a very different space, as the court articulated in FAIR itself, looking at Woolley and Barnett, where you are intruding on the mind and the spirit to force someone to create a message that violates their convictions. FAIR would be a very different case if the law schools were to have advocated for the don't ask, don't tell policy. In terms of whose speech it is, that's come up a few times. At worst, it's both. Third-party perceptions cannot possibly matter to this case, or we wouldn't have any of the other compelled speech doctrine cases. Barnett, Woolley, the newspaper cases, all of those, you wouldn't have any, and the government would have unfettered authority to compel speech because we would all know it was the government that was doing it. In addition to that, the definition of public accommodation. My friends on the other side are playing a little fast and loose with what the statute says and how they've interpreted it in the past. The statute says a place of a public accommodation. On page 41 of Colorado's brief, they say that applies to virtual sales as well, meaning the soccer mom earning some extra income, trying to sell her handmade sign. She's a public accommodation under this law. It is broad, and it would take away First Amendment rights for opening a business. Certainly, Michelangelo's speech was sold and commissioned, but we would all say it had protection. In addition, the idea that we can't give a bright line. The bright line we give is the line that this court has consistently followed. And I find it ironic in the United States also having to concede they can't give a bright line. For some reason, political speech is protected, but religious speech is not protected under this law. The bright line is the message affected? And as Justice Gorsuch brought up, that line is massive when it comes to the distinction between pre-made speech, plug and play, and speech that you are creating in a custom way. In conclusion, Ms. Smith's speech has been chilled for over 6 years, and the record demonstrates every website she would create a custom message that is celebratory.
Not bad.
Colorado asked this court for the power to drive views like Ms. Smith's from the public square. Views about marriage that this court has held are honorable and decent, promises that it has provided that the government would not mandate orthodoxy. Cultural winds may shift, but the compelled speech doctrine should not. Compelled speech crushes the speaker's conscience, and it is the tool of authoritarianism, which is why this court has never allowed it. In the end, it is not Ms. Smith who is asking you to change the law, but Colorado. This court should affirm, again, that public accommodation laws cannot be used to compel speech, and this includes artistic expression, photography, painting, calligraphy, and films, forms of media that the lower courts have shockingly refused to recognize as speech when it comes to marriage.
Nice.
And yes, this court should give guidance to limit the cruelty that has been imposed by endless litigation on artists like Jack Phillips. One need not agree with a particular belief to affirm that law-abiding people have a right to speak their conscience, including on a controversial subject like marriage. And that noble principle is rooted in love of neighbor, extending the same rights to others that we want for ourselves. This right to be free from government coercion of speech is also foundational to our self-government and to the free and fearless pursuit of truth. Thank you. This court should reverse.
Thank you, counsel. The case is submitted.
Not bad. Not bad. Yeah, I said it was a little emotional. I think maybe I should retract. I think on balance it was well done. I would have given the speech a little bit different, but I think, it was a good summary. That was good. It was a nice little epilogue to it. And she points out how it applies to virtual sales and how political speech is protected, but religious speech is not. And she points out how Jack Phillips has been subject to lawfare, points out that public accommodation law cannot be used to compel speech, and this includes artistic expression, photograph, painting, calligraphy, and films that lower courts have refused to recognize. So, I think on balance it was actually pretty good. Let me read some super chats that came in during the time today that we've had today. And thank you, by the way, for everyone who helps to support this channel as always. It really does help the channel grow. It makes things possible in the future as finances will allow. It will allow me to get a second room that I can use as studio space. It will allow me to travel, for example, to Idaho to see the Daybell Vallow trial, perhaps in person, and other things that will be nice. So we do appreciate it because it helps things that will be helped to facilitate the channel and will help us all to learn a little bit more. Kiwi New York Upstate gave $5 to say, this sounds like any person can be forced to do work for anyone, then they cannot decline. It sounds like slavery just because they have a business. No, that's not exactly correct. No, I mean, the place, no, that's just overly broad. Joseph gave $4.99 to say, it's if Soto is seeing the website as a publisher, a site that reproduces another speech. That could be true under some circumstances, but isn't seem to be true here. It's like that's what she wants to be true. Like there's not enough creativity in it, which I suppose kind of makes sense. If you're, just a website that produces websites for other people in a very sort of form-fill way, then maybe. Kiwi New York Upstate gave $5 to say, can you say your profession requires a high level of quality of work and you're unable to uphold that with a particular client and be done with it? No, not at least under the way that the courts are reasoning this. Fair and Balanced gave $10 to say, thanks for covering this. Was going to email you when this happened for an interview for my story, but protesters assaulted the free speech lawyers. That became the story. Will you cover the election case today? Which election case? You mean, is there one being argued at the Supreme Court? If you mean the one, if you mean that's being argued at the Supreme Court, I typically covered it a day or two later once the audio was synced. This happened yesterday. The audio was available, or happened, what day of the week is it now? Happened Monday. The audio was available late Tuesday. It was too late for me to do it, so I did it today. So it typically takes a day or two for me to get around to it. And I still have other things to do because I still haven't gone to the whole Twitter files, which I wanted to do. And I still haven't gone to batch recording stuff. And I'm behind a little bit on the curve. Rain432 gave $5 Canadian to say, I see a common thread with a lot of these cases recently. I want the government to force someone to do what I say or want them to. Fundamentally evil. Fair and Balance gave $5 to say, so a 3 of 3 creative wins, which they obviously will. It depends on in the nature of how, but yes. Does this throw out Colorado law where you have to do straight and same sex in business? No, it doesn't. It doesn't overturn that case. That case was interpreting the statute dealing with the Civil Rights Act, Section 7 of the Civil Rights Act. That case did not have a constitutional dimension to it. It was a straight statutory interpretation, and I can't see any particular reason that this case would overturn that case, so no. But those were the super chats that came in today, and thank you very, very much for all those things. The restaurant just canceled reservations to a Right to Life group. That's potentially because of things everything gets complicated. Also, it's not, I'm doing an awesome job. Well, thank you, Alicia. I appreciate that. I appreciate that you say I do an awesome job. I try to make it awesome for you. I try to make things better for you and everyone else and try to make things more enjoyable. And I appreciate everyone who's here. Improvidently granted because the stipulated facts are too speculative. I don't see that happening too. Truth for Liberty. I really don't see them kicking this one down the road. And the stipulated facts did go on for like 10 pages. I thought about reading them, but it was quite lengthy. If you're interested in reading them, by the way, they're attached to the petition for certiorari. They're included there along with the 10th Circuit decision and the district court decision and other cases. So it's there. I thought about reading it, but it's like 10 pages worth of stipulations. So it's a little lengthy. Matthew says, I know the member of the board of directors for Alliance Defending Freedom, the 303 attorney group. Want me to try to get a PR person to contact you? I wouldn't necessarily be interested in a PR person contacting me. One of their lawyers wanted to talk to me in some way. That might be interesting. But I don't need PR persons. I'm more than able to possibly. Jennifer says, I love how your brain works like a computer. Thank you. Canceled by the LGBT staff said that he would not serve Christians. Is that actually what they said? I don't know what they said or what they didn't say. I mean, I don't know what happened. Ezra said, realize allowing one corp to discriminate based on religion means all corps get to discriminate based on religion, and Amazon doesn't like Christians. Amazon is not based on speech. Amazon would not fall into this category. Amazon's business is logistics. There's no the First Amendment aspects of Amazon's business is incidental at best. And so it wouldn't fall into this category. Can you send me a box of puppies? No. No living things to my post office box, thanks. Nancy says, that was very enjoyable. I appreciate your presentation opinions. I'm of the opinion that people should have absolute freedom to be jerks. Then you know who you're dealing with. Amazon owns Switch. Okay, well, as to Twitch, then we could have a discussion, I suppose, but okay. Amazon owns Twitch, IMDb, Goodreads. Well, then let's talk about those companies. You asked me about Amazon. I'm like, well, Amazon's major company is logistics. If If you want to talk about Twitch, then ask me about Twitch. I'm sure they can find a way to make it not incidental. I don't know about that. Okay. Well, to the 451 of you who are here, by the way, I really appreciate it. Don't forget to do all those YouTube things. Remember to like the video, comment, subscribe, all that good stuff. Shiri says, I appreciate the coverage. You're getting so much more comfortable streaming live with us and seem to be enjoying the interactions more. Thank you. Don't forget to do all the YouTube things. I guess I'll sign off for now. I probably will try to do more recording today. I might do it off stream. I haven't decided. And at some point I really want to do the Twitch, the Twitter stuff, and I just haven't had time for it. But yeah. Until later, my friends, I've been Uncivil Law. I hope all is well, my friends. Until later, my friends, peace and goodbye.